Excellent. No, I'm going to lead meeting.
Let's see.
Nice that Zoom gives me that option.
I'm just gonna leave.
Bye, Yaron. I don't want to be recording.
Here we go.
The radical, fundamental principles of freedom, rational self-interest, and individual rights. This is the Yaron Brook Show.
All right, everybody, welcome to Yaron Brook Show on this Thursday, January 12th. God, January is already almost in the middle. Time just flies. Second show today, and I am particularly pleased to have Dr Mossoff join me today. Thanks, Adam, for joining. You've all got Adam's formal biography in the description below. Adam is a professor of law at George Mason University. He has also got a degree in philosophy. He is a longtime objectivist and one of the original students of the Objectivist Graduate Center in the good old 90s.
Ancient times.
Remember those days. So we were students together in some classes.
Yeah, it's great.
And yeah. So thanks, Adam. Thanks for joining me. This is I don't know, your second, third time on the show, but I really appreciate it.
Well, thank you for having me. It's a great way to kick off the new year.
Absolutely. This is great. So you guys know the drill. If you have any questions, try to focus them today on law, constitution, property rights, intellectual property rights, patents. But we'll go broader than that. But let's try to at least get a bunch of questions around that. We have an ongoing competition among the people I interviewed to see who can generate the most super chat dollars. So Nikos has set the bar pretty high. So we will see how we do with that. But it's up to you guys. It's up to you guys. All right. So I want to get to intellectual property rights, which people always have an issue with, and it's always good, even though we've talked about this in the past on the show. It's always good to kind of dig deep into it and remind people and bring it up to kind of up to where we are today. I also remember you have some interesting things to say about China, so I want to talk about China as well with regard to intellectual property rights. But I want to start with a kind of a broader view of property and property rights. Rand has a particular view of why property rights are so crucial. And why, in a sense, of the essential right derived from the right to life. But historically, where does the right to property intellectually, where does it come from? I mean, who are the key figures? And then how is it conceptualized kind of in let's say in the founding era?
It's a great question. Excuse me. And so in the modern era, I would count, from the approximately, the 17th century up to today, it's large, the people, if you said, who's the primary intellectual source for our understanding of property today, I think people would rightly identify John Locke. John Locke, he moved beyond a lot of kind of the initial errors of the founders of natural rights philosophy, the modern theory of natural rights philosophy, Hugo Grotius and Samuel Pufendorf, and really situated the right to property within an understanding of why government needs to protect it and why government needs to be limited just to the protection of the rights to life, liberty, and property. And he conceptualized it properly as a result of that. He saw, it's fitting within this trinity of life, liberty, and property.
So how did he connect it to life? I mean, how did he see kind of the Rand's view that we have to produce in order to survive, and therefore that make that connection to life?
Unfortunately, no. At least not explicitly. So, I mean, there's inklings of it because he was on the right track and he was very reality oriented and he was very, he's really an incredible, philosopher and, very ahead of his time. And, but, he was still shackled by, his commitment to religion, and they could not bridge the Izak gap. He couldn't. They did not know how to get it started. So what did it mean that you had a right to life? And so from that perspective, they really just thought that, well, just God basically says you have a right to life, and that's what starts it all. And Hugh Grotius also has this kind of notion as well as kind of implicit that you do have to kind of produce and act in order. This is why you have a right to liberty, because you have a right to life. And so you act in order to sustain your life. And in acting, you make things, and you make those things, Locke's famous phrase, you mix your labor, which was his metaphor for productive activities. And that's what then creates the right to those things, or right to property. And you can see it's kind of implicitly running throughout. And this is one of Rand's, great insights and contributions of her many of them, is that she actually recognized the key issue that they all missed, which is that it's man's rational mind that is really guiding everything, and that it is the rational mind and the values that man identifies through the use of his reason that actually is the basis of property as serving one's life.
So is the fact that they didn't realize this, did that result in a kind of in a sense, a materialistic view of property?
Somewhat. I don't know if it's materialistic or intrinsic.
Okay.
And the two are similar in some ways, but they're still distinct from each other. And this comes out of the initial inability to objectively identify and ground this concept. And so natural rights has the sense of that it's natural in the sense that it's intrinsic in you as a person. And this is, where you get all these people who struggle with, well, what does it mean then when you delegate your rights, and how do you lose your rights if it's intrinsic in you, and things of this sort. And this is, Rand's incredible achievements also in epistemology, that she recognized, no, these are concepts, these are principles that serve our life. But because they had this intrinsic view of rights being instantiated in you in some way, shape, or form as part of your metaphysical essence, so to speak, as a rational being, it did orient them ultimately toward kind of a more physicalist conception of rights at times. But then again, Locke also had in his theories, inklings of, well, no, it applies broader than that. Property can be extended to this. Even in the second treatise, he talks about how, well, even when he's describing his theory of property in his chapter called Property, chapter 5, he's giving examples of property, and he even says that grass that is bit by the horse of my servant is my property. And that's a really, really incredible, insightful insight that, that you can alienate and transfer down through these rights, and that, you can have moral claims and legal claims that extend out beyond you to things that you've entered into agreements with people over. Mm-hmm. And so, they were slowly kind of gravitating toward it, but it really took Rand's, theory of objectivity, and her real key insight about reason as man's basic means of survival is kind of breaking the Gordian knot that they had all been struggling with for so long, and fully justifying and explaining what is property.
And what do you think the consequence of being of that Gordian knot, the fact that they didn't have a full explanation? And they recognize property rights, they mm-hmm. recognized intellectual property rights. It's in the Constitution after all. And what caused it to fall apart? I mean, clearly we don't have a full understanding to this day of property rights and the role of government. Where in the chain does it fall apart?
Oh, yeah, great question. So first, it falls apart philosophically, because, of course, wrong, all the way from just plain wrong to vicious and evil philosophers always understand what the fundamental error is. And so the philosophers that followed on Locke, especially philosophers like Bentham, who infamously referred to natural rights as nonsense on stilts. Yep. And so he was going right to that foundational point. Like you basically start with this bald-faced assertion that we have rights because God says we have rights, and that's just nonsense. You can't validate that rationally. So immediately it lost its philosophical foundation as justification. And the founders really weren't philosophers, so they couldn't respond to that, and follow-on legal scholars couldn't respond to it either. And then because of the intrinsicism and some of the mistakes that they had in their theory, like they embraced this notion of eminent domain, for instance, which is in the Constitution. And they didn't have a full conception of what it means for government to be limited just to the protection of individual rights. Those were also chipped away at slowly. The government has police power, and this notion of this police power slowly expanded over the 19th century and encompassed more and more regulatory controls on property in the name of the public good. And so you get the combination of this kind of philosophical attack and reinforcing and driving this legal attack, and it starts to fall apart by the end of the 19th century.
Yeah, and of course today we're left with even somebody like Scalia saying rights are nonsense on stilts, and there's the I guess supposedly the sexiest thing in law schools these days is common good constitutionalism from Bemule at Harvard. So
there's actually not everyone embraces that. This is really interesting.
No, they don't embrace it. It seems like the students. It seems like the hot, sexy thing, right?
A lot of people have embraced it. And it's part and parcel of this kind of broader, yes. I think cashing in on the collectivism and the implicit collectivism of conservatism and shifting to its populism, right? In the classic, historical statement of the Vox Populi, Vox Dei, right? And so of course, if it's the voice of God, it's also the voice of the people. So they're now, yes, it's all just about letting the people decide and letting the people do whatever they want. And, we should let the levers of government power, is one of their phrases, be used by the people to express their interests in what we're trying to achieve.
So I was going to get to this much later. We'll come back to property rights in a minute. But does the popularity of Bemule worry you? I mean, is this a trend that you think has legs within the legal community? And I think for him, it's more than just democracy. I think for Bemule, it really is the voice of God. I mean, he is a Catholic and believes in using scripture to govern.
Yeah, I know. He's like unreconstructed, pre-Renaissance,
scary stuff.
Which is very interesting. I actually had him as my law professor.
You did?
He was at Chicago. It was before his conversion to Catholicism. So he wasn't like that when I had him as a law professor. So it's just been very interesting to watch this development that he's undertaken. It's among legal scholars in the Federalist Society and on the right of center, for lack of a better term. There's actually a very robust debate going on about common good constitutionalism and because one of the things that common good constitutionalism does too is it's taking some kernels of truth and it's leveraging them. For instance, the kind of the implicit legal positivism that's inherent in originalism and textualism, Scalia's, that if you want to write, put it in the Constitution, but otherwise there are no rights that don't exist in the Constitution.
Tell us what legal positivism is, because I'm sure a lot of people don't know.
Yeah, so legal positivism is typically the theory that was contrasted against natural rights. So these are kind of the two opposing theories of rights in history before objectivism, which is the natural rights say you have rights that pre-exist government, but it's the intrinsic view that they're inherent in you as a person, and God-given, and then the reaction to that was people by Bentham and many others, which said, no, rights are created by governments. Rights are created by laws that say you have a right. So a positive expression in a statute or in a court decision, and that's the source of rights, and that's the only source we have. I mean, they say we look out in the world, I don't see rights, but I see legal documents that tell me I have rights, and that's why I have rights.
And that's
the subjectivist view.
Sure.
And so this is kind of the classic historical clash between intrinsicism and subjectivism that Ayn Rand rose above and recognized and identified the errors in both and fully validated rights. Mm-hmm.
And in this sense, the common good conservatism represents the intrinsic side, and it's replacing kind of the originalism or textualism that was popular among center right?
Well, originalism and textualism are still very, I mean, those are the dominant methods of legal and constitutional interpretation right now. In large part because the left and the opposing side didn't really have a methodology. It was living constitutionalism, which is not really that's not a method. It's pure subjectivism, just as the Constitution is whatever we say it is at any particular point in time. And so, originalism was a reaction against that. So a legitimate reaction. And of course, but then they went intrinsic and said, well, the way we understand the Constitution as not being this subjective, open, blank slate is by understanding it solely in terms of what the founders understood it to be. The common good constitutionalism is kind of reacting to that, saying, well, but that's kind of a positivist slant on things, because you're still saying it's what the founders gave us, and we have society for a moral ideal. I mean, so the common good constitutionalism is appealing to people's sense of we live for a moral purpose. Societies are good and bad. And you should have a flourishing society. Your notion of what is a good society is fundamental, and that has been lost in textualism, and it was never part of textualism and originalism, which is, I think, a right identification. And so again, you can see, so they're going intrinsic because they're going more fundamental. And of course, the only thing that exists more fundamentally in the moral space is religion, if you believe in a right and a wrong.
And what would you think their attitude is, or I think towards property rights, for example?
Yeah, so well, property to them, this kind of fetishization of property is completely wrong, right? There's the point is not individual rights. The point is not rights to life, liberty, and property. The point is having a quote good society, right? The common good constitutionalism, and of course, the good society to them is the good society is defined by people like St. Augustine and others. And so this is kind of what their appeal is. And so they're actually very, very much viscerally reactive against anything from the Age of Enlightenment and the Age of Reason. They dislike Locke. They dislike the appeals to that. And they argue sometimes when they try to invoke the founders that, it's a mistake. They really weren't, driven and motivated by Locke. They were driven by, Thomas Aquinas and St. Augustine and other more, and religious leaders. Yeah.
I mean, I've been doing talks at Federalist Society. I did a few at the end of last year. And this is what they want to talk about. I mean, they want to talk about this new theory in law. It's the exciting thing, and it appeals to their idealism, I guess, right? Because it is kind of a more philosophical. It has a vision. It's not just let's follow a text, but there's an ideal that we're striving towards, and I find it incredibly scary that this is the future of the Federalist Society, potentially, not now, but 20 years down the road when these kids, or that this is the future of the right, because I think seems to be the direction the right is heading towards. The ideological vacuums don't survive. Yeah. And this seems to be one of the things that is trying to fill that vacuum.
And it's a great example too of Ayn Rand's point that fundamentally people in a choice between being practically effective and being morally right, people will choose to be morally right. People are driven by what they think is good and right, not what should be practical and effective, which is kind of how conservatives and economists try to argue these issues. So this is why I think you've rightly identified, it's so appealing to especially young people.
All right, so let's go back to property rights. So, obviously the founding fathers understood the ideas of property as best anybody could, I think, during the Enlightenment. And they, to what extent did they, make that clear in the Constitution? To what extent is the Constitution as a document that protects property rights?
Well, that's a great question, because I think there's a lot of confusion about this about what is the Constitution, because the federal Constitution's job is not to protect property rights. Okay. And so because the federal Constitution was to restrain and limit the federal government. So we have two systems of government. We have the state governments and the federal government, and so what the founders were creating was the federal government, which was very, from their perspective, small, weak, and primarily its job would be to have an army and a navy to defend the country as a whole. And
even then, not a standing army, if I remember.
Yeah. So this day we don't have a standing army. It has to be renewed every 2 years. They pass a bill to renew the military every 2 years. Yep. And essentially to prevent the states from warring with each other and destroying each other, even through their own policy. So this was the problem under the Articles of Confederation, as the states were adopting regulations and trade protectionist measures against each other. And so they created the federal constitution and a federal government to enforce basically a free trade zone between all of the states. And so they didn't view it as their job to, it wasn't the job of the federal government to protect property, because the federal government doesn't create property. Property was already recognized and secured through the common law, which were the courts, and that was at the state level. And in fact,
and they weren't worried about the fact that these rights would be lost and that these rights needed protection.
Well, so that was the debate between the Federalists and the Anti-Federalists as to whether we should adopt the Constitution. Was, have you sufficiently limited the federal government such that it won't aggrandize more and more power to itself, and thus essentially become an authoritarian regime and replicate through kind of through a demagogue, what they were escaping under King George. And so there were founders who recognized that there was a concern here and that the government wasn't limited enough even in the original document, which is why we ended up with the Bill of Rights, which, by the way, weren't even identified as the Bill of Rights at the time. They were just the first 10 amendments. So you have, for instance, with the federal government, you have doctrines like it's the doctrine of enumerated powers. So for instance, the federal government is limited in the way that, in this sense, it has no powers other than those expressly granted to it. And so if it doesn't have something that it explicitly says it can do, it can't do it. Of course, that's been totally lost. That was the destruction by the early 20th century American progressives, capital P progressives, the leftists at the time, which has unleashed the administrative state. So they saw themselves as creating a radically new system of government that wasn't just a federal government, but was a new government system in the sense of also we had the federalism, where the states were actually viewed as the primary protectors of the rights of life, liberty, and property, and the federal government was the backstop against that essentially at the time.
So over the 19th century, as we kind of start losing rights to property, and whether through eminent domain, but also through lots of other regulations and controls, and right of contract gets lost, and through the regulatory state. What is the debate going on? Is there a debate among legal scholars around this idea of property rights? Is that a conception which covers, I don't know, Lochner and things like that? Is that a conception that covers contracts? Do they perceive it in that way?
Yeah. So there are a lot of different scholars who are doing different work on rights, on property rights. There's also, a lot of lawyers who are doing work on this, Institute for Justice and the Pacific Legal Foundation and many others. Their mission is to protect property rights and to restore the rights of property and the rights of contract. But you can't talk about protecting the right to property without reducing it ultimately down to a discussion and debate about, well, is the administrative state legitimate or not? And should we have regulations, and what type of regulations if we do, and things of this sort. And the moment you start to enter into that space, majority of people today don't want that to happen. They don't want to get rid of the regulatory state, what lawyers call the administrative state, or the welfare state. And so there's not a fully robust discussion about it, but there are people who are trying. I think there are some people who are trying to bring it back and are trying to engage with it at a theoretical level. But a lot of those people are, still working within kind of historical traditions and of Locke, and so they still have a lot of the same similar mistakes that you see that Locke made and other natural rights scholars made.
So when you see somebody like Gorsuch, who came into the Supreme Court with, there was a lot of hope about his opposition to the administrative state. I mean, to what extent is that opposition, do you think, motivated by an understanding of property rights, even if not a full understanding, or is it something else? Is it more separation of powers issues for him?
Oh, and yeah, that's a really interesting question. I don't fully know. So I mean, if I was to guess, because he cares very much about separation of powers. But one reason why he cares about separation of powers is he sees that as an essential mechanism that was innovatively created by the founders. I mean, there's so many things that the founders were,
right.
It's amazing. They're just such incredible men, such heroes. And but he sees the reason why he believes so fervently in the separation of powers is because that he sees that as an essential mechanism for limiting the government and leaving people free in their rights to life, liberty, to exercise their rights of life, liberty, and property. So in a certain sense, he does see it connected to property, as a right to property, as a right to contract, but he also sees it as, well, but a key part of being a lawyer and being a judge is actually thinking not about moral concepts like what is a right to property, but thinking actually about the legal institutions and the legal doctrines and the processes that we to use in society to protect those rights, like the doctrines of separation of powers and the doctrines of federalism and things of that sort. Now that's distinguished. So Gorsuch is, he's actually fairly good as a justice. I'm impressed with him, and I'm not saying that simply because he cited my work.
Okay, good.
But that because compared to Justice Kavanaugh. So Justice Kavanaugh is a what you would call a process conservative. So he thinks he's like what we were talking about with respect to originalism and textualism. It's just all legal positivism at the end of the day. It's just as long as the government follows the proper processes, that's fine. And so he's more than willing to rubber stamp raw exercises of power as long as the government crossed its T's and dotted its I's under existing illegitimate doctrines that exist.
Mm-hmm. Anybody else, on the court with better views in terms of rights and in terms of the role of government?
Well, I mean, Thomas historically has been better. But he's becoming a little bit more mixed now as he, as he starts to get very much caught up in the concerns about, big tech, and he's now views them as a monopoly, and he thinks that they should be, addressed as such. And also he's become very anti-IP. Yes, he's written many of the really bad opinions in the past 10
and he wasn't always
years. Not always, in fact. In the 90s, he wrote one, a really good patent opinion in the 1990s. But I think he got heavily influenced by anti-IP libertarians who were clerking for him. I know some of them personally as classmates. And I think also Justice Breyer was also very anti-IP, and he played a very significant role in the Supreme Court in influencing its patent law and its patent decisions. And I think, he also helped influenced Justice Thomas somewhat in that respect.
Interesting. That's too bad. I mean,
Thomas. By the way, that's a theory I have. I don't have any direct evidence of it, but just my observation.
It doesn't surprise me. I mean, something is off with Thomas over the last few years. It's hard to tell exactly what. There's a certain pragmatism that is set in, and he used to talk about individual rights. He actually used to talk about them. I think that's out these days.
He assigned, he would give his clerks the fountainhead.
I think he still does. I think they annually get together and watch the movie. I don't think they actually read it. I think they watch the movie once a year. So I think that is ongoing. I think his understanding of the movie has deteriorated.
I mean, it used to be that this was that Thomas and Scalia kind of represented kind of the two forces that were intellectual powerhouses on the Supreme Court, in terms of Thomas, very explicitly rejected the legal positivism of Scalia. So one of the key differences between Thomas and Scalia is Thomas really believes, and still to this day says this, that the Declaration of Independence is an authoritative source that they should be able to cite for interpreting the Constitution. Whereas Scalia is on record saying the Declaration of Independence is a bunch of rhetoric, It's beautiful sounding, but it's not legally relevant or meaningful to what I do as a justice. And I think that division says it all.
And I don't think there's anybody else that agrees with Thomas on the court right now, with that view of Thomas's.
That explicit view. Gorsuch might, and we haven't seen enough of Justice Barrett yet to know, where she might ultimately come down on some of these matters.
Okay, so let's talk a little bit about IP. Locke talks about mixing your labor with the soil, right? How does that then get translated into intellectual property rights? To what extent did they have a proper understanding of the intellectual property rights? And, how does that lead us today with so many so-called defenders of freedom or anti-intellectual property rights?
Oh, yeah. Great question. So as a preliminary matter, when Locke used his phrase, you mix your labor with things, and he's been really viciously attacked by this by contemporary philosophers and Jeremy Walder and many others. Oh, this is just nonsense and things of this sort. I think they're dropping context. I mean, when you read it, it's clear he means it as a metaphor. In fact, Locke liked metaphors. He uses a lot of metaphors in a lot of his philosophical writings. Because when you look at all of his examples of what he means by mixing labor, they're all examples of productive activity, of someone taking something in nature and converting it into a human value, whether it's like killing a deer to make steak or the famous example of picking acorns, but he also talks about like making wine out of grapes, a very important activity.
I don't know what they knew about that in England. I don't think they had any clue about that in England. Still don't, based on my tasting of British wine.
Yes. Well, they read stories about it being done in other countries. He did, and if you read his other works too, and I've written a little bit on this, he did have a nascent idea that you do have to kind of create and produce things in order to live, that we are not like animals, that in his treatise on human understanding and his works on education in particular, he talks about how learning virtue is fundamental to living a happy life. So virtues themselves are values. You have to pursue them and achieve them. He actually talks in those terms. It's really interesting. And so he has a nascent understanding of this. And I think this is reflected in the fact in 1695, he writes a little essay on copyright, where he actually identifies copyright as a property right of an author, which is really unusual at that time, because this is pre like copyright as we now understand it. And he does refer at the very end of his chapter on property to kind of he supposedly refers to innovation as kind of a value in society that you want to promote and will follow from protecting property rights. So he had an inkling of it, but we have to recognize in the 17th century in 1690 when he wrote the second treatise, they didn't have intellectual property yet. They didn't have we didn't have patents as property rights protecting inventions. We had government granted monopolies. We didn't have even copyright yet. Copyright was a government granted monopoly to publishers from the crown. So it's not until the next century that and it correlates with the Industrial Revolution, at the start of the Industrial Revolution, that people start to recognize, people are creating machines that are of value to us, that these machines are necessary for human survival, and that their productive labor goes into it, that they should have a right to it just as much as a farmer has a right to his field, and we should protect it. And so, how did
we get from there to where we are today with this? So, I mean, it strikes me that there are more people attacking property rights from the so-called right or from the so-called free market side than there are people defending it. Yeah. You're one of the few out there fighting the fight to defend it. How did we get, freedom and lack of the negation of property rights mixed in together with the pretense of freedom anyway?
Yeah, it is. It's a real conundrum. And I spent a long time trying to figure it out. And I think the key is that utilitarianism in Bentham and this kind of in economics. And so what in legal and basically a more positivist view of the matter of things, in the sense of that, people continued to read Locke's treatise, and they said, yeah, this is kind of mushy sounding rhetoric, mixing labor and picking acorns and things of the sort. And they also, and Locke does have some intrinsicism in his theory of mixing labor, because he wasn't an objectivist. He didn't fully understand these are values created purely through the rational mind. And so, people felt like, well, really, we need to be able to provide a solid rational foundation for this. And this comes from Bentham. So really what we have is not mixing labor. What you have are conflicts. And that's observable. That's a fact. No one can dispute about this. There people are beating each other up with clubs or eventually guns over a piece of land. So how do we have an understandable baseline to resolve a conflict? And of course, that baseline, they say, is property. So they starting now from property is arising from value creation, which is Locke's implicit point, not explicit, but implicit, to now property being explicitly serving as a function of resolution of conflicts.
And scarcity, that strikes me as, this is the whole idea in economics, that scarcity is the fundamental idea, and land is scarce and ideas are not.
Well, economics then provides the theory that explains this conflict resolution. Well, why are there conflicts? Because no two people can use that same piece of land at the same time in different ways. It's a quote, scarce resource that is inherently rivalrous. And so they start from that premise. And then if you start from that premise, well, inventions and books and all the other types of, even corporations, which are abstractions, are not scarce and rival. They can be recreated and used by multiple different people in different ways without there being conflicts over in the same way you have over a piece of land or a river. And so they immediately see this as not property. And and therefore, if a government is securing this, it means that this is a monopoly grant.
And so, so the typical libertarian out there thinks that intellectual property rights are just a creation of government and therefore a statist issue. Yeah,
well, creation government and therefore a statist issue, or even worse, they see it as a violation of our property rights because, hey, if I copy this machine, I made the machine, it's mine. So you're telling me that I can't use it is actually violating my rights of liberty and property.
And is your sense that is that view gaining ground among, in the world around us, both intellectually and from political perspective?
So that view, it's not gaining ground. That became, it's dominant in libertarianism now. Because Murray Rothbard embraced it. Yep. There's also a huge overlap between anarchism and libertarianism and opposition to IP, because of course you need a government to recognize and enforce the rights in intellectual property. And so they tend to, then intellectual property has to be out too. And so this kind of, anarchist, utilitarian, economic scarcity so-called justification for property is really dominant in libertarianism right now. And this is why we see a lot of rolling back of protections of intellectual property in the United States in the past 30 years, is because you have libertarians openly joining with explicit leftists and collectivists to attack intellectual property. So you have the Cato Institute joining in legal briefs at the U.S. Supreme Court and amicus briefs with leftist organizations like Public Knowledge and the Center for the Democracy and Technology to attack patents, copyrights, trademarks.
Wow. So we've got a lot of questions, so we'll get to those. But so where do you see this heading? Are you optimistic, pessimistic about kind of intellectual property rights in the next decade or so?
So if you had asked me that question 5 years ago, I would have been much more pessimistic than I am now.
Okay.
So I'm, 5 years ago, it was, you could not break this patent troll rhetoric that had come to dominate Washington, D.C. and was being exploited by libertarians and the leftists and the FANG companies who are funding a lot of this because they in a very short-sighted, pragmatic way view IP as contrary to their business models. So it's not a theoretical issue to them; it's just a business model issue to them. But I'm more hopeful now because I think a lot of people are now recognize the concern and problem here. Good people and people who recognize that intellectual property is fundamental to a successful economy, a successful free market. It's very interesting, that libertarians who will beat up on Marxists for, having, not looking at the facts of the world and just having their theory and imposing their theory on the world are doing that with their attacks on IP. They have this economic theory that tells them that IP is not property. And yet they know nothing of actually how intellectual property has actually driven the entire industrial revolution, has driven our biotech revolution, has driven the computer revolution. It's property rights, which are the basis of contracts and companies and venture capital investments and everything of that sort. And so it's and there are a lot more people who are starting to write about this and to talk about this and engage on these issues. And so I'm a bit more hopeful now. And also, you mentioned China. China has helped in this little respect because they copied our patent system, but they did that because it's part of their socio-political agenda and goal as an authoritarian regime. And so that's actually helped us a little bit because this growing conflict with China, intellectual property is now being viewed as part of that conflict, and it actually is.
So the fact that the Chinese stolen intellectual property rights is something that bothers people?
Yes. Yeah. In fact, China ends up being kind of for people, it's another conundrum. They're like, we constantly accuse them of stealing our IP, which they do. Billions of dollars, it's estimated a year. And yet they've developed their own very, very strong intellectual property systems in their own country. And it seems like a paradox at first, but if you recognize, no, well, they go together because China, what they want is they want to get as much invention in their country as possible so that they can rise as quickly as possible so that they can then, become militarily dominant and dominant in the world. And so this is all part and parcel of kind of a domestic industrial policy that they have.
So they have a patent system locally to encourage entrepreneurs and investors. Mm-hmm. And then from a foreign policy perspective, they'll steal all they can from the West.
Right. And the result is more technology for them. And
well, they think it doesn't. As we know, it doesn't work ultimately that way.
Well, in the short term, short term, it works, right? Yeah. And in a certain sense, every authoritarian leader knows this isn't going to. We're going to run out of people to steal from at a certain point.
You have to tell Putin that because I don't think he's learned that lesson yet. And he's running out of people.
Yeah, he surely is.
Horrible fashion.
A horrible regime. Yes, yeah, but
China was. I talk about this a lot on the show because I care about China, but China seems to have been on the right path and veered off into this, real authoritarianism. I don't know if that's your sense as well.
100% my same sense. I was so hopeful, and in 2010, 2000, even 7 years ago, I would have said China is a real serious, going to be a success story. And Xi is like a switch was thrown because he ultimately had to make a choice, let the free market continue to grow and develop and let people be innovative and creative, secure patents, or,
lose power as a consequence.
Lose power. And he chose power, and they've become, very authoritarian. And so, I think that we're going to see the same story play out now with them as we saw with the Soviet Union and other authoritarian regimes.
So when you say they have a strong patent system in China, to what extent is it backed up by a rule of law? So if somebody steals my patent in China, they might have violated the law, but can I actually get at them, particularly if they're members of the Communist Party and I'm not?
Yeah, that fantastic question, because China, they kind of thought they studied the United States, what made us successful. By the way, this is explicit and known. They said, their patent system, it's clearly a patent system. So they think we'll take their patent system and we'll be successful too. If we build it, they will come. It's no, it was the US patent system worked because it was part and parcel of a system of the rule of law, the protection of individual rights, stable political and legal institutions that were restrained to the protection of individual rights and the rule of law. And so, but in China, you have this veneer of the law, right? You have you have things called courts. And,
Yep.
and they superficially follow processes that we see as you file a complaint, you have discovery, but they're not courts. Like in any authoritarian regime, if there's an issue that the Communist Party cares about, then the Communist Party is going to tell the court, you have to rule a certain way. We've seen this repeatedly, actually, in patent cases. And so, it can't be successful at the end of the day, because you can get as many patents as you want, but if you're not protecting these patents as property rights in a system of a rule of law, then they're worthless. And the innovators will figure that out. People who think, the rational people.
Yeah, I mean, I've always thought of China as having kind of pseudo property rights, right? They give everybody the impression they have property rights until you piss off the right authoritarian leader somewhere, and then poof, your property, whether land or IP, is not yours anymore. It's gone.
Right. That's, they're Chinese, communism with Chinese characteristics, right? It was kind of like, well, we'll create a veneer of capitalism, and as long as people don't interfere with our fundamental, more authoritarian commitments, you can be capitalistic and free. But the problem is, eventually there's going to be a conflict. There has to be, and then they're going to have to make a choice. And Xi's clearly in the past 4 or 5 years making the choice that no, power and authoritarianism is what matters most to me. Yeah.
Yeah, I still am hopeful that they'll somehow find a way to get rid of him. We will see. It doesn't look like it. It looks like he's solidified his position, but they're going to struggle economically. They're going to struggle in other ways, and maybe that'll get people upset. He did fold on zero COVID, so
yeah, which was surprising. I wasn't expecting that.
No, neither. Neither was I.
So, but I
don't think the protesters were expecting it. Yeah. I think they were surprised. They expected to line up in jail. Many of them did.
Yeah.
So, but they were not expecting to be successful, and they were incredibly successful.
So Yaron, so I'm interviewed in a documentary called The Innovation Race, which talks a little bit about this issue with China and how China is using patents and innovation and technologies as a way to kind of challenge the United States and to rise as a global power. It's the first kind of authoritarian regime that's recognized this, and so it presents kind of this unique challenge to the United States that we didn't face with the Nazis and Soviet Union, because that was a military conflict. They thought they would dominate us militarily. China thinks, yeah, we will eventually have to dominate the United States and other free countries militarily, but what's going to drive that ultimately at the end of the day is technology. They have kind of a superficial recognition of that. And so they're trying to promote technological innovation and economic development for that reason in their country. Yep. And so it's just kind of a race between like how far can they get in the short term before it all collapses in the long term.
Have you read I don't know if you've read this book that I'm recommending to everybody, because I think it's really fantastic. It's called Chip Wars. Chip War, by Chris Miller from the
no, I didn't, but I'm going to get it now.
It's really good, and it gives you a whole new perspective on what China is doing and why it has to fail in some sense, but also, my perspective on Taiwan has changed. My perspective on a lot of things geopolitical has changed, and the book is basically just a description of the microprocessing industry since the days of Shockley, all the way to today, and it's fascinating. And right now, I think I can't. Semiconductors seem to be like, maybe with exception of energy, maybe semiconductors are the most important industry in the world right now, because basically we have a chip in everything, whether we need one or not. And Musk is trying to get chips into our brains, so we'll really have a chip. But it's very well written, and it's really interesting.
Yeah, a computer scientist actually computed that there are now more transistors on the planet Earth than there are leaves on trees. I mean, because there's hundreds of thousands of transistors just in your smartphone.
I think there are billions of transistors in your smartphone. I think
probably,
it's stunning. And when you read the book, you'll just be blown away by how stunning it is, and by how much this will be right up your alley in a sense of how much has been achieved in 60 years, right? If you think about Shockley and all of that, in the 50s, semiconductors were still like these big things with rods in them and stuff, and now you have chips that are almost as thick as an atom. It's mind-boggling. And
Yeah,
anyway,
I've read about the
highly
chip
recommend it.
manufacturing, the fabs.
Fabs, and of
it's
course, all that
fascinating.
happens in Taiwan now, and the way that happened, just really, really interesting.
You know,
So,
so China has recognized this is probably in the chip wars and how they've been trying to develop their own domestic conductor manufacturing, and it's been completely decimated in the past couple of months because of the law that we passed that no U.S. citizen or a company can work for a Chinese company, because these aren't private companies, right? Huawei is not a private company; it's an organ of the Chinese Communist Party, and so they were all U.S. people who left China, and they were all the people with the knowledge and the know-how.
and it turns out, I mean, this comes out of the book. It turns out that even if you have all the knowledge and the know-how,
Yeah,
you can't make sophisticated chip without the tools to make sophisticated chips. There's only one company in the world that makes the primary tool to fab these chips, and it's a Dutch company.
mm-hmm.
That company, in order to build its machines that fabs the chips, has contracts with, like, I don't know, hundreds of smaller companies, all based in Western Europe and in the United States, to produce lasers and mirrors and stunning stuff that and if China's cut off from that, if basically China's cannot buy the mirrors from Germany, there's no way it can produce, it can compete with Germany on mirror. Germans have been making mirrors for cameras for well over 100 years, and they have the patents, and the Dutch company is called ASML. And so you get a sense of the supply chain, and you get a sense of what it takes, and you suddenly realize that China can know everything. It can have the talent, it can have the people. It's always going to be 10 years behind at least, because if the West chooses not to deal with it, and right now in semiconductors, the West has chosen not to deal with them. So whether that, some of those laws are good, some of those laws are bad, but the reality is that we have chosen not to deal with them, and they're screwed. All right.
I mean, they've been fighting. They've been essentially in an undeclared Cold War with us, right? For I think for at least 20 years now, and
I think certainly since Xi came to power. So I don't know if it's 20 years. I don't think that I don't know that they conceptualized it that way pre-Xi, but I definitely think they've conceptualized it that way now.
And so I think some of this is good. I mean, some of it's bad, as you said. We shouldn't be shutting.
We shouldn't be subsidizing our own chip industry.
Oh, certainly not.
Tens of billions of dollars picking winners and losers.
Oh God.
I also think that it's reasonable to say we shouldn't be selling the most advanced chips in the world and the most advanced chip making technologies in the world to China when we know that all those chips land up in weapon systems.
Yes.
It was interesting. They took a bus on the drones that the Russians are using in Ukraine, that they are buying from the Iranians. And what's inside the drones? American chips. Literally American chips. And this is a country that's supposed to be embargoed. So let's get chips to the people who want to destroy us. Let's sell them. That makes complete sense. All right, let's see. Adam has a question for Adam.
All right, awesome. I have a question for myself.
Why are so many patent cases taken to the court with the least literate jury pool in the country? Their belief that illiterate jurors will be directly guided by God, or more likely to be swayed by scams.
That's okay. So, well, the jury. Look, you think juries in the 1830s were any more literate? And I mean, in the 1830s, you had patent trials over the electromagnetic telegraph, the mechanized reaper, vulcanized rubber. Right, before there was chemistry, before we even knew what electricity was, and you had juries, right, who couldn't either read, or if they read, they only had read one book in their entire lives, and that was the Bible, right, at that point. But they figured this stuff out. Those cases were good and right, and they reached a lot of the right decisions. And I'm less skeptical of juries than other people are, because there's a certain sense in which juries can kind of cut to the chase, because you can really, especially in patent law. Oh, it's the monoclonal antibodies with the valence levels with the protein receptors, and you can just start talking about all that stuff. But but at the end of the day, it's like, well, describe the invention in the real world. What is this thing that you've invented that's of value to humans? And having juries who don't have PhDs is actually really good, because it forces lawyers to have to think about, like, what's the real world reality, technology, what's the focus of what we're doing here that matters, and it prevents them from getting caught up in a lot of the technical details and theoretical issues. In fact, they don't, in patent trials, they usually don't have PhDs as running the trial, because the worst person ever to talk to a non-technical person is a person with a PhD in molecular biology or something. So they usually have someone with with a philosophy background or a political science background, because they're the ones that know how to talk to regular people.
That makes sense. So from your experience, tracking these trials and being part of, I'm sure, many of these trials,
yeah.
A jury still, even today, making decisions that make sense for the most part?
Yeah. Yeah. I think, I haven't done all the empirical studies. The
Sure.
problem is that you have kind of a selection bias, in the sense of, of course, you hear the news reports of all the crazy decisions and the crazy ones, right? And you have to realize that there's thousands and thousands of cases that occur every day where everything works out, and the right that's been infringed or violated is adjudged as such. A lot of trials also aren't before juries. So you have a right to a jury, but you only get a right to a jury there if you both ask for it,
Okay.
Or one of you ask for it. Sorry. So and there are a lot of cases where the parties say, no, we want to litigate before the judge. There was a massive worldwide patent wars, they're called, between Ericsson and Apple that just settled last month. And that was before a judge in the Eastern District of Texas. So that, it wasn't before the jury.
And it actually, is it the case that almost all of these cases get settled without going to
Yeah, well, yes, a lot, or they start the trial and the person eventually settles, because the moment you realize we're going to lose this, you stop wasting money on your lawyers and you settle. So Apple settled with Ericsson, and Ericsson was sued for patent, or Apple was sued for patent infringement by Ericsson. And there's actually a filtering, right? So you have complaints that are filed, and a lot of cases settle at that stage, because you immediately know that person figures out, oh, I'm in the wrong, I'm going to lose, so why should I waste hundreds of thousands, if not millions of dollars on lawyers? I'm just going to settle now. Or you go through discovery and some pretrial motions and things like that. So you hear about kind of the crazy cases and things of that sort, because those are the cases typically also at the end of the day where there really is an issue in which you have arguments can go either way, essentially under the law as written, or as the nature of the patent, or the nature of the copyright, or even a dispute of regular property. And that's why you kind of get those prominent cases that are in the newspapers about those issues too.
Cool. All right, Marilyn asks, has the Ninth Amendment become meaningless?
Mm-hmm. Yeah, the Ninth Amendment has largely been meaningless.
Say a little bit about what the Ninth Amendment is, and in what sense it's become meaningless.
Thank you. I should have said that. I'm not just jumping in to answer the question.
My job.
You're doing it very well, Yaron. Gold star for you today.
There you go.
As I say to my students sometimes. So the Ninth Amendment is the amendment. So when they enacted the Bill of Rights, the first 10 amendments, one of the arguments about why we should not enact the Bill of Rights is they said, well, if we enumerate all of these rights that can be protected, that leaves a logical implication that the rights that we're not explicitly saying can be protected, like the First Amendment, the right of free speech, or Second Amendment, the right to firearms, can be abridged, can be violated by the government. And so to address that, Madison wrote the Ninth Amendment, which says essentially any rights that are not specified as protected in the Bill of Rights are still secured to the people. So it's kind of a recognition, it's a reaffirmation of the kind of the natural rights philosophy that animated the Constitution, that animates the Declaration of Independence that Thomas used to refer to a lot, but it's for people who are positivists in inclination, like Judge Bork, who was a very positivist, originalist, he literally said the Ninth Amendment is an ink smudge. He literally said that. He's like, you can't.
Well, I mean, if you don't recognize individual rights, then the Ninth Amendment is kind of meaningless.
Yeah. He literally said it has this legal standing of a smudge. You can't, we don't know what it means. It's just meaningless. It's so we can't enforce it. And there it was cited a few times in the 60s, by the Warren Court. But of course, it was caught up with their living constitutionalism. So they were invoking it. Oh, yes, there's all these unstated rights and we can create new rights all the time. And because rights are whatever society say they are. And so the reaction against that was very strong. And so for all intents and purposes, it's the dead letter in the Constitution. Yeah, unfortunately.
Is there any legal movement, legal scholars out there that want to kind of resurrect a proper view of the Ninth Amendment?
So there were, Randy Barnett used to write a little bit about this, and others, and I know that the libertarian law firms, Pacific Legal Foundation, Institute for Justice, right? They, see that also as an important amendment. It doesn't, because of its dead letter in law, they don't want to invoke it a lot, but it's very much part of kind of, I think, their overall strategy of what they see as bringing back into American law in a more effective way.
Mm-hmm. Good. All right. Let's see. Len asks, patent trolls unchallenged me on 3-element water chemistry. Okay. Ignored RAMBUS fiasco, betrayed DDR2 group, Qualcom built on patents, accountants and lawyers, drug companies buy patents, jack up prices, and users suffer. Okay. So give us a spiel on patent trolls.
All right. So patent trolls is Ayn Rand used to say, you should always ask people to define a term. And if they can't define it and there's no settled definition for it in discussions, then that's an indication to you that it's a anti-concept, it's a package deal, it's an invalid concept, an invalid term. And that is certainly the term patent troll. It's a term. It essentially has come to mean any patent owner that has sued me for patent infringement. It was effectively used in the policy debates in Washington, D.C. To very effective, in a very effective way, to push for legislation to weaken and eliminate patent rights that unfortunately the FANG companies, Facebook, Apple, Amazon, Netflix, Google, and Cisco and a few others, supported and spent hundreds of millions of dollars pushing this narrative, funding, bogus junk social, studies, statistical studies that tried to show that there's patent trolls are causing all this damage and whatnot. They would never define it because, if you say to them, what is a patent troll? They'll say, well, it's someone who doesn't manufacture. Well, you say, well, Thomas Edison didn't manufacture. Is he a patent troll? Oh, well, not him. So it's someone who has a bad patent. Well, but there are people who don't manufacture who sue and their patents are held to be valid.
Yep.
And so Apple was just sued by VSLI, a so-called patent troll, because it doesn't manufacture. It has what you call a licensing business model, and which is what Thomas Edison's business model was. So was Tesla's, so was Charles Goodyear's, and it's property rights, and their patents were upheld. So, but they're smeared as being patent trolls. Universities have been smeared as patent trolls because they don't manufacture. And so it's a rhetorical term that's been used by people to attack the patent system. And it's captured good people who are like, yes, because there's always some bad actors. There's always some bad people out there doing some bad things, with even with their property rights, abusing them. And there's other doctrines in the law that address that, and there are in patent law as well. But you don't need this term patent troll. In fact, they had a term in the 19th century. Their term for the 19th century was patent shark. People attacking the patent system at that time were called there's patent sharks. These people who don't manufacture, who just license their patents and attack people, and they're bogus and all sort of stuff. And we should get rid of the patent system.
So as a finance guy, I know people who raised money, went out and found people who own patents, bought the patents from them,
Mhm.
and then went around and sued companies for patent infringement. Is there anything wrong with that?
Nothing wrong with that whatsoever. I mean, how about I buy a piece of land? I don't live on it. I don't build on it. Someone's trespassing. I sue that person for trespass. Am I a property troll? No, more fundamentally, what these companies are is they're financial intermediaries.
Yep.
They are serving a really important function in a free market, and that these inventors and others, people who are there buying their patents from, are people who are undercapitalized, or lack the knowledge of how to enforce or license their patents.
Mhm.
And the business model of these companies is not patent litigation, because litigation is expensive, and who wants to pay a bunch of lawyers millions of dollars over the span of many years to go through multiple courts and appeals to eventually, it's the business model is licensing. The business model licensing is contract. So I've created something. I am not going to work with it myself. I'm going to give you the right to do so through a contract. And in intellectual property space, we call those licenses. And there are, licensing is a long-standing, fundamental, key part of what makes a free market work. Contracts. And in fact, economists have identified it was a unique part of the protection of US patents as property rights, that inventors didn't have to manufacture the way they did in England and other countries, that they could license their rights to the people who did have the skills to do those things. So that facilitated the explosive economic growth through the division of labor and specialization in the Industrial Revolution and in the 20th century with the pharmaceutical revolution and the computer revolution.
And do you know what this RAMBUS fiasco is?
So RAMBUS was a company that did something bad that about 25 years ago, where it was part of there are these organizations called standard development organizations that develop technological standards, like which are universal. Your three-prong plug is this technological standard. USB. These are set by private companies. They go by weird acronyms like ETSI and IEEE. I'm a member of some of these. I'm a member of ANSI and IEEE. And they engage in and RAMBUS engaged in some shenanigans where they participated in the development of a standard without telling people they had patents that covered aspects of that standard. And then when the standard was adopted, they then turned around and started suing people for using their patented technology. And so of course, standard development organizations are private organizations. They recognize if we let people do this, that's bad. That undermines and prevents standards from being adopted. So they all adopted rules prohibiting it. So as private organizations, as part of the agreement that when you join a standard development organization, you agree not to engage in what's called patent ambush in that context. But by the way, that was one company. And standard development organizations have been around for 100 years. With patents covering their technologies, and billions of dollars are exchanged through standard licensing of patents on standards. By the way, the Ericsson Apple case was a case over standards. It was a dispute over 5G, the use of Apple's use of 5G technology that had been developed by Ericsson. By the way, Ericsson is a patent troll because they just license. They don't manufacture anything.
They used to. They don't anymore. Right?
They used to make phones. Yeah. Nokia is a patent troll. They just license. They don't make phones anymore either. Qualcom is half a patent troll because they license. They created 5G, but they also make chips. Well,
they design chips. They don't actually fabricate chips anymore, right?
They don't say, they are closely connected with the companies that make them, such that they're viewed as making them, essentially, in the same way that Apple is viewed as making the iPhone, even though it literally doesn't make the iPhone. Yes, by licensing. I mean, this is how it works. Yeah, this is why your iPhone, when the box says designed in Cupertino, doesn't say manufactured in Cupertino. That's licensing. Yep. Yeah.
All right, Jennifer. Jennifer says, hello, Adam. Can you comment on the recent story regarding right to repair involving John Deere?
Oh, yeah. Well, hi, Jennifer. And so the right to repair movement is again, this like patent troll. These people kind of created this furor over something that really wasn't a big deal, but because they wanted to attack copyright. And so they're like, all right, we really want to roll back copyrights. We want to eliminate the ability of people to have copyright protections in their software that goes into the computers that are used in tractors and in cars and in your toasters. And so they said, oh, you have all of those, computer software in there that's protected by copyright and other IP protections. Well, that prevents people from repairing their cars and their toasters and whatnot. And they got farmers all riled up about this. It was what we call astroturfing in policy debates, where organizations go and find people who are sympathetic, like who can be opposed to American farmer, and they, manufactured this huge attack on IP, and have been. And it's a huge attack. It's being well funded because it's in 50 states lobbying for state legislation and in the federal government. That doesn't happen unless there's coordination and millions of dollars behind it. And so, of course, some states have adopted, a few states have adopted right to repair legislation, so to speak. They adopted under their antitrust powers, which automatically tells you, they call it unfair competition. So it's automatically tells you.
Nobody can compete with the Yaron Book Show because nobody can use the words Yaron Book Show. Nobody has my mind, and
you're a monopolist.
I'm a monopolist.
You have a monopoly.
And John Deere is a monopolist because nobody else can make John Deere equipment.
So this development is really awesome because it shows you that the market, will evolves and develops and people respond to it. John Deere wants its customers to be happy. John Deere does not want angry farmers who don't want to buy its tractors anymore because they'll buy tractors from someone else. And so, and to the extent that farmers were having legitimate concerns, there's always a small kernel of truth that they're leveraging in these debates. John Deere recognized that, and so they entered into what's legally referred to as a memorandum of understanding with various associations representing farmers that they will be provided the means and be supported in repairing their own tractors. But what's really interesting about this agreement, which makes it even really cool, is John Deere also recognized all the political machinations that are going on because they made it as a condition in this memorandum of understanding that if the organizations that they made this agreement with start lobbying for right to repair legislation, the MOU is canceled. So this agreement, this memorandum of understanding, this MOU, this agreement is automatically canceled and done with. So it was really good, and it's a really good development. It shows you that to the extent that there is a kernel of truth that's always leveraged by
but how much of it is a kernel of truth and how much is it blackmail?
Oh, it's like 0.05% kernel of truth and 99.95%
blackmail. Yeah, that's what I
yeah. But so I co-authored what's called a policy brief, a shorter white paper on state efforts to adopt the right to repair and why actually these conflict with the under federalism with the federal protection of copyright, that states aren't allowed to do this even because states were basically effectively trying to take away copyright owners' rights protected under federal law, and they're not allowed to do that.
All right, Shai Levy asks, what would be the role of common law in a proper society? IIRC is in one interview, Rand extemporaneously likened it to implicit philosophy, fine at the start, but necessary to make explicit in statute to become civilized.
Yeah, great question. And I'm going to be talking about the common law as distinguished from civil law systems, which are statutory-based systems. In my course, I'll be teaching the Ayn Rand University on legal systems as an intellectual achievement. So common law, which means...
So let me remind everybody that the Ayn Rand University is a sponsor of this show.
Yes.
You should all go sign up to take Adam's course. You can be auditors. You don't have to be graded students. You'll learn a ton. You can go to university.aynrand.org.
Yes. And by the way, that was not coordinated at all between us.
No.
Yeah, that was totally.
It just happens that most of the people I interview happen to be teaching courses at the Ayn Rand University. So
well, I'm really excited to teach this course because there's no textbook for it too. So I'm bringing together materials, court opinions and chapters of books and things of this sort. So common law is judge-made law, for those who don't know. And the reason why it's called common law is because it started in England with the king's courts, which were common to the entire realm, which is how it came to be called common law. So you got a judgment from the king court as opposed to a county court or an ecclesiastical court, a church court, or the a merchant's court, which were only enforceable between the people who participated in those areas. There's a real epistemological virtue to common law systems, which is they're inductive. So this is the problem with statutes in civil law systems is you have legislatures who are starting with, well, this is how we think society should be organized, top down, theoretical, and the common law is bottom up. It's so it starts with Farmer Joe and Farmer Smith have a conflict over a cow. And so they go to a judge and, hey, Smith took my cow. How do you know that, Joe? Because the cow is now on his land. And the judge decides the case and then writes it down. And then the next time there's a dispute over a cow, they cite to this earlier decision as a basis to understand how to decide the new case. And you have, through this process, an inductive development of law. And it's very inductive, it's very reality oriented, and it's very much consistent with our view of government as being restrained to the protection of rights. So there's a correlation between civil law systems being very statist and common law systems being very free and more individualistic, because the government is a passive institution. It just sits there and waits for people to come to it with their disputes. And so it's not a coincidence that the common law was really a good legal system and developed really well. And it's not a coincidence that the administrative state, the regulatory state, is a civil law type system. It's top down and it's really, really bad. And the reality is that the common law was never a pure, just court-made system. Every legal system is a mixture of statutes and court decisions. The question is, what's the ultimate source of some of the ways in which the law is being developed and the law is being understood as how to be applied to new situations? Because the reason why you're in court is because there's an open question about how the law applies to it. You can't foresee every conceivable situation because new inventions, new ways people are interacting, just human mind is always creating new values. And because this is why tons of cases settle, because they immediately figure out, oh yeah, the law easily applies to this. So it's only when you actually have a new situation where it's unclear and there's colorable arguments on both sides, that's when you have a court decision. And that's what makes, in a common law system, that's forces the courts to be very inductive. They have to, they're basing it in the facts brought to them by the litigants. And it's, and there's really strict rules of evidence and rules of procedure, which, by the way, Congress doesn't follow. Congress doesn't have to follow rules of evidence. It doesn't have to base its decisions, as we know, on things.
So what do you think Rand meant when she said, but really to become civilized, you need to have this legislated law?
Yeah, this is, it's, I think
you can disagree with Ayn Rand. It's okay.
Yeah, no, it's not that. I know I can disagree with Ayn Rand. So yeah, I don't want to imply that I'm struggling with the fact that I might be disagreeing with her, because I'm not, because that's not my struggle. My struggle is trying to understand fully what she was framing. And I think she was making a point of intellectual history, that what you have is if you have systems that are purely common law, eventually there have to be statutes that do codify and formalize what's the law, because you do have rule of law and what we call notice concerns. People have to know what the law expects of them.
The objectivity of the law, and making it objective in a sense. Yeah.
Yes. And so for instance, everything used to be common law, including criminal law. And in the 19th century, they started to codify criminal law in statutes for precisely these reasons. They said, well, if the coercion of the state is being brought to bear against people, they really need to know beforehand what are the terms and conditions of which this is going to happen. And they don't know when it's judge-made law as well as they would if it's codified. So, but for private law disputes, property, what we call private law in legal theory, which is property, contracts, torts, so issues of disputes between private individuals, I think that really should remain actually a fundamentally a common law type system.
All right, so we have a ton of questions. You're going to be here for a while. I hope that's okay.
Oh, I don't mind. I'm happy to keep going as long as you have energy. I love this.
So then I'm not doing any talking. You're the one who needs the energy. All right. So Len says, you have started the tech revolution with IP, with Einstein in a patent office in Bern, I think. Well, he was, but that didn't start the tech revolution. But is the kind of structure we have today with the patent courts, with people owning patents, with the lawsuits, with all the conflict that generates, and all the, is that the best we can do? Is that the best system we have?
No, but that's not because of the patent system. The patent system is not immune from all of the bad influences of the irrationalism and the collectivism and the statism and and all the other kind of attacks on rights and reason that we have in our society. And so the patent system has been affected by that just as much as as we see, contracts being affected by that and corporate law being affected by that. And so it's not the best system we have today. Now, could it be worse? Yes, it could be a million times worse. And there are a lot of people who are working to try to make it worse. And we need to defend patents. In the same, Ayn Rand, she recognized you have to defend capitalism wholeheartedly, and she had that great saying, I forget, I think it was in the Anti-Industrial Revolution, where she says, if you see a sooty, smoky, smokestack, thank that for giving you life, right? And because she was making a fundamental point about what is at stake. Mm-hmm. And with all of its problems and, in litigation and things of this sort, the patent system, is still, at core, a fundamental part of what has made America, a free, flourishing, successful society. And
so what big changes would you make to the system to make it better?
So one is go back to our first to invent. So we used to be first to invent from the very first patent law statute that was enacted by Congress in 1790 all the way up in 2011. We were unique in the world. In fact, the whole argument about why we need to get rid of this is because the rest of the world doesn't follow this. Well, right, because we viewed patents as property rights, as the property right of an inventor who created it. And now we're what we call the first to file system, which makes it more like this is like an economic regulatory entitlement. It's just whoever happens to make it to the patent office first gets the patent. You don't have to be the inventor anymore. Also getting rid of this horrendous institution created in the same law in 2011. It's an administrative tribunal that was created at the patent office whose sole purpose is to cancel and eliminate patents. And it's an administrative tribunal. It goes by the acronym PTAB, stands for Patent Trial and Appeal Board. And it's exactly what you would expect of any other regulatory agency. They don't follow due process. They stack panels to reach preordained results. They have canceled tens of thousands of patent claims. People get 50, 60 petitions filed against the exact same patent. And it's the valuable patents that are being attacked for this very reason, because they're valuable patents. And this is massively undermined the reliability of patents as property rights, their stability, the certainty that they provide for investors, for innovators, and for business persons.
Okay, Michael asks, what would the self-defense laws look like in a free society? It seems as of now, only Texas has decent self-defense laws by allowing the use of deadly force in defense of property as well as person.
So I don't know Texas's law, and I'm not an expert in self-defense law in terms of what are the specific laws and things of that sort. But I do know a bit, and I've thought about these issues, especially when I was explicitly studying legal philosophy. So you do delegate your right of self-defense to the government when you enter into government, and that's really important and significant. And now you're not giving up your rights. And so this was John Locke's innovation over the people who came before him, who really thought, like, when you created government, you really did give up all your rights to the government. He said, no, you're delegating it to protect it as your agent. But that does mean that the government has legitimate monopoly on the use of force in the defense of rights in society. Now, you do have the right to own a gun. It's why it's in the Second Amendment. You do have the right to defend yourself. But the presumption is that it's the government that actually gets to exercise coercion. So you can, and I do believe in every state, I could be mistaken about this. If you are under a threat to your life, you have a right to use deadly force to defend yourself. And by the way, anyone who breaks into your home, that's understood as automatically a threat to your life. If they're willing to break into your home at 1 a.m., they're willing to do more worse things. and so these are as what Locke referred to as the dangerous and noxious creatures who have quit the law of reason and need to be removed from society. And so but if
you know anything about these retreat duties where you're supposed to retreat from deadly conflict?
Yeah, I'm more, because how you define that and things of that sort. Now, but what I think should happen though is when you use force to defend yourself in your home and things of that sort, right? Well, the presumption should be you used force, so the police have to investigate that. Mm-hmm. And they have to make sure that this was actually properly, objectively a use of self-defense. You shouldn't just get off like, oh yeah, I was defending myself. So that's all I need to say. And so I do think that there's an obligation of the state to investigate claims of self-defense because it's very serious. And because vigilantism is not allowed, and properly so. You are not allowed to take the law into your own hands. But the boundary line between defending yourself and being a vigilante it's not a clear, bright line at times, and that's why you need investigations by the police to ensure, and by district attorneys to ensure that it's properly self-defense.
Yeah, absolutely. All right, Justin says, can you explain what the principle is that makes a product design element patentable?
Yes, what Justin is referring to, let me back up, is there's actually three patent systems we have in the United States. The one that everyone thinks of is the patent system, patents for inventions, what Thomas Edison got, and we actually call those utility patents. We also have a design patent system and a plant patent system. Because plants present kind of interesting, unique issues that are distinct from, because they're living organisms and they self-replicate, from machines, which don't. But you also have this design patent system, which was created in the 1830s, where you can get patents on designs, and literally designs, like the design of a tapestry, or the design of on things of this sort. But they have their own rules because designs are different from inventions too. But they follow the same general requirements. So it has to be new. So you have to have created it. So if someone had created it before you, then it's not. Then we're not certain that you didn't copy it, and it's just not the byproduct of your own actual rational mind and creative labor. It has to be you have to what we call disclose it. You have to describe it fully in your patent application and eventually in the issued patent, such that people can look at it and understand it and know how to replicate it once you go off protection. It has to be useful. So it has to be useful in the world. It has to be a value. That's the patent system's recognition of that these are values we're protecting, and it has to be non-obvious. And this is that's a really hyper technical issue in patent law. I'm not going to get into it too much. Just to mean that it can be, something can be new and useful, but it's just such an obvious logical next step that it's not something that you really want to grant a patent for. So the classic example I use when I teach patent law is someone invents the bicycle, and then which is a patentable invention and was patented, and then someone invents a tricycle. It's like, well, it's kind of obvious putting 3 wheels after someone had 2 wheels. There's not really an invention going on, an active invention going on there. So those are the same requirements in design law, but they're framed around the specific nature of designs, as distinguished from inventing a machine or a new process or coming up with a new plant hybrid.
And the idea here is there is real economic value to design, and it is a product of an individual human mind.
Yes, designs have to be in their values. They're created by humans. You don't go out in the world and find designs. And in fact, a lot of the patents that Apple sued Samsung on, they sued them on both utility patents and design patents. And in fact, the trial ultimately ended up being about the design patents. And a lot of people are like, oh, like the slide to unlock. oh, like that's so obvious. Well, there's a saying we have a saying in patent law, every invention after it's been created is obvious, because once a person has solved a problem, if it's a good solution and it really solves the problem, then it's hard to, like, of course it's hard to get out of that context anymore, and of recognizing, yes, that had to be the solution. And so we've lost the context of what it was like, before slide unlock, where you had to have a phone that, you come up with a phone with a screen that people have been trying to come up with, that you could easily turn on, but without, what we proverbially refer to as the butt call, and without needing a mechanical button every single time.
Yep. So Apple sued Microsoft for Windows, right? For the same kind of thing, right? For the object, like the trash can. Like
Yeah.
that, if I remember right.
Yeah. They sued, yes. So
for the user interface, which is also designed.
Yeah. Yeah, and they settled. Because Bill Gates said, well, all of your patents, you got a lot of that from Xerox, because actually Xerox was the one who invented a lot of what we now take for granted as our modern personal computers, the trash can, the icons, the calling it the desktop, the mouse, everything. That was actually invented at Xerox PARC in the Bay Area in the 1970s.
All right, let's see.
By the way, there's a myth that Steve Jobs stole it from Xerox. He didn't. He got a license from Xerox. Xerox licensed it to him because they couldn't figure out how to make their personal computer inexpensive. Their personal computer cost $30,000 in 1972. And so they were like, there's no way he's going to figure out how to solve this problem of making personal computers cheap. So we're happy to license to him, because nothing, we'll just make some money off a few that he'll sell.
Yeah. Dean asks, hey, Yaron, can you talk about art and property rights, or music and property rights?
Mm-hmm.
Did Ayn Rand have a point of view in the subject? Also, my friend Gina really likes your show, and she says hi. Hey, Gina.
Hi, Gina.
Right. So art property rights, music property rights. Obviously, this was a big deal with was it Napster? We were still alive. Most of my listeners would, but we remember those days, right?
Yes, yeah.
And there were big arguments at the time. I remember everybody was downloading music, right? Everybody was stealing music, and it was like,
not me.
It was very uncool. I know, me neither. And it was very uncool not to be one of those who were using Napster. I was in Silicon Valley, and it was like everybody.
I know. I was like, this is you can't do this. You're violating their copyrights. Well, Ayn Rand did have a view on this. I mean, she recognizes copyright as being a valid property right in her essay, Patents and Copyrights. In fact, she speaks more to copyright than she does to patents in that essay, which really is another indication of just how objective she was, because she herself was a creator of copyrighted work. So she understood copyright law. She recognized, I don't know as much about science and technology and patent law. So she kind of left that to more general statements about what it does. So copyright should protect creative works, like songs, movies, artwork. And there's requirements for, it has to be creative, and it has to be something you created and things of that sort. And written down in some type of tangible form, but the digital form is a tangible type form. And it really shows you the influence of kind of the whole perspective of, but if property is about conflict resolution, where's the conflict? If I'm copying a song, you can still listen to your song, and I can listen to the song too, and there's no conflict there, so where's the conflict in this? And it really shows you how that whole framework just completely perverts your understanding and basis of that these are property rights, and the presumption should be that they should be protected to the creators, within the scope of what they've actually created and within the scope of their legitimate property rights, because there are limits to them as well, and they're legitimate limits. And I actually have a talk on that from an old conference on why there are time limits on patents and copyrights as well.
Okay, the Lightning Goza. No idea who that is. Hi, Lightning. With Google versus Oracle in mind, is it moral to buy or use an infringing Android device, or perhaps further, any Google product? How do you judge mixed companies and whether or not to interact with them?
Yeah. Well, Oh, by the way, I think that's a Ghostbuster reference. Goza had the lightning that came out of her fingertips. I'm more of a geek.
You're more of a geek than I am. You can tell by the characters in the background there.
Yes.
No Spider-Man in my
Spider-Man, and there's a Star Wars droid behind my head and some other Star Wars things. Great question, right? And by that question, we used to debate and discuss these issues even before the internet and before Android and things of this sort, because companies are mixed, people are mixed, and and so what are the principles for how you interact with those types of people? By the way, I have an Android phone. I've always had Android, I'm not
one of Adam's few flaws.
And I love my Android phone. I think it's so superior to an Apple. But I joke sometimes when I give talks, I'm like, and here I am with my infringing smartphone product. It is, it's a good question, where do you draw the line, between, in deciding how to interact with people? Because your job is not to be, I forget who, was it Diomedes with the lantern and in search of the one just man in ancient Greece. Your job is not to be assessing every aspect of character of every person you interact with, and same with every company as well as legal persons. Your job is to define the context of your interaction with them. And as long as, and within that context, is that an appropriate context? Now, there are some companies and organizations and people that are so bad, right, that there isn't any legitimate context, but that's those people are that's like the Communist Party or AOC or something like that. This is, Samsung, infringed Apple's patents, and guess what? They were found liable for that, and they paid for it. They had, I think at the end of the day, it was about a $350 million judgment that they paid to Apple for that infringement, and they went on. And by the way, it's really interesting to note that while Apple and Samsung were in a lawsuit with each other, Samsung was providing chips to Apple because Samsung is this massive conglomerate. They build ship engines and airplane parts and all sorts of. So while in the time that they're suing each other, Samsung is in Apple's supply chain.
And they're competing with one another. And I always tell people, capitalism is about cooperation much more than it is about competition.
Yeah. So while you should pay attention to these things, and I think it's perfectly fine for someone to say, look, I care about this issue so much, I choose not to do that. I think that's perfectly fine, but you have to also recognize it's perfectly fine too for, I think in this context, for other people to say, they're a company, a legitimate company, they got in a dispute, it got resolved, they paid for it, and they've continued to move on and innovate. And the Galaxy phone is actually a great innovation. In fact, to be frank,
I think this is Google versus Oracle, right? So that was a case where didn't Google steal a bunch of code from Oracle?
Yeah. Okay. So I'm sorry, I'd forgotten that it was a question about, because he asked about Android, and I got
I know.
Thank you for that. Yeah. No, I was involved, and I filed an amicus brief in that case and followed it very closely. And the Supreme Court's decision was awful. It's just horrible decision. They said you can't have copyright protection in computer programs called APIs, which are the programs that make the entire internet function. Those are the computer programs underneath the hood, so to speak, that allow your email client to communicate with your computer, that allows it to communicate with the internet server, that allows it to communicate with another computer, where this is code. And this was a case where Google created the Android and wanted Android to become a quickly valuable product. And Oracle, actually, it was Sun Microsystems at the time. They got bought by Oracle. Sun Microsystems had developed Java, and Java, which became the dominant API program that was driving the internet. Java made the internet. And so they realized we need Java if our new Android smartphone is going to be out of the gate successful. And at that time, Sun Microsystems had 4 licensing programs, 4 different licensing. One of them was a free one, was an open source free one but the requirement was you couldn't make changes to it. And they were like, no, we want to make changes to it because Google wanted to take the program and they wanted it for free, but they wanted to make it proprietary too. So Android is open source, but it's open source within a proprietary model of the Android system. And so, and there's all these internal emails that came out through Discovery where they literally were saying, yeah, we can't make a good API. We need Java, and none of their license programs work, so we're just going to take it. And this was undisputed. They stole 13,000 lines of code from Sun Microsystem in the Java APIs and just put it on Android. And eventually Oracle buys Sun Microsystems and Oracle sues for a whole slew of things, patent infringement, copyright infringement. Eventually just becomes an issue about copyright in the code because it was undisputed that this was copyrighted. They took it without authorization. It was a copyright violation. But Google came up with this, oh, it's fair use because it serves a functional purpose, everyone needs it. It's essential to running devices. So you can't have a monopoly through copyright on things. And they were able to convince the Supreme Court with that argument. Now, it was awful. And by the way, I have lots of criticisms of Google as a company. They've been a source of the destruction of a lot of our patent system in the past 15 years. And it's well documented. But like I said, I use Android, because I haven't decided that it's an immoral company to the point that I'm not going to use it. But
it's not, so many companies, all companies that, you mentioned Sun Microsystems, whenever they're mentioned, it reminds me of, they're the ones who sicked the antitrust lawyers on Microsoft in the 1990s.
Mm-hmm.
And Sam McNeely, by the way, at the time was on the board of the Cato Institute. So here's a libertarian CEO of a company using antitrust to go after a competitor.
Yeah.
It never ends. If you can find a pure company out there, and you can't sacrifice your life in the name of seeking that purity.
Right. I mean, and especially in today's world. I mean, right, exactly. In today's world where there's so many bad ideas, you're not going to find that good, pure company any more than you're not going to find a lot of good, pure people either. I mean, are you gonna find how do you know your grocer that you purchased your Fruit Loops from last week is a good person, that they're not lying to their spouse and having, illicit affairs without knowing, and or stealing money or something? It's not your job to investigate those things on the basis of principle. It's not, the principles are for you to be a happy person, to give you the tool set to be a happy person, to live a flourishing life. And that helps you understand, if there are bad people, the reason why I don't want to interact with them is because they will make my life bad. And so, you can personally decide as a personal matter, you don't want to interact with Google, but I don't think it's a moral matter, at least at this point yet. It might be, there are some companies that get really bad, but those are standout cases.
All right, Melvin asks, what areas of the law are you optimistic about?
Oh, these are great questions. You have a great audience. I love
great
these
audience.
Yeah, these are great questions.
And they put money behind the questions.
They put their money where their mouth is. It's great. So what areas of law am I optimistic about? Yeah, that's a great question. Because it's, because the problem is that what you had is we started with good law, really good law in this country. And then it's been all bad. It's just being attacked and it's being destroyed and degraded through, the bad philosophical premises that are being deployed then through politics, statism, collectivism, irrationalism, the religion. And that seeps into even the good areas of law. So for instance, I used to, patent law has been affected by this. The class that I teach now in patent law is completely different than the class that I started teaching 20 years ago. And it's not as fun for me to teach it because it's not as good. It's been degraded. I don't enjoy teaching it as much as I used to. So what areas of law am I most optimistic about? Well, there's the core kind of private law areas, are still kind of our bulwark. They are what keep our society going. A lot of people, when they think about why we have government, they think, oh, we need government to stop those dangerous and noxious creatures I referred to, criminals. And that's an important part of government and society, because you can't have society, civil society, if you have criminals running around rampant. But the government serves a much more fundamental role than that. It effectuates and makes possible good people to live their lives by providing a framework through legal institutions and legal doctrines like contracts, torts, and property, for good people who end up in disputes with each other to have those disputes resolved. And resolved without having to resort to force, resort to self-defense. Because it's been common law, it's been kind of a bulwark. It's what's been continuing to drive our society. It's been kind of the basis by which people have been able to continue to do what they've been able, all the good people have been able to do what they've been able to continue to do. So I'm optimistic that will hopefully still kind of stay the way it is, but it is being degraded nonetheless.
So Lightning Goza says his name is not a Ghostbuster reference.
Oh, that makes me sad.
I don't know what it is, but
yeah.
You'll have to enlighten us, Lightning.
Yes.
All right. What's Adam's opinion? This is Richard. What's Adam's opinion on net neutrality? For example, should AT&T be able to lower priority content coming from Comcast properties like NBC Universal?
Okay. So let me ask that question in a more fundamental sense. Can a property owner fundamentally make a decision as to who can use its property and under what terms? Whether who can come into your home, or if you're a hotel operator, do you get to decide who gets to rent hotel rooms from you? Or if you're a plane operator, you get to kick people off your plane who are causing problems and things of this sort. So AT&T, which spends billions of dollars to create the foundational infrastructure of the internet, they put in the backbone of the internet and the primary servers that carries the traffic and everything. Can they then decide how that is used? I think in principle, you have to understand the answer has to be yes. It's no different than any other property owner, whether they're a railroad or an airline or a factory owner or a homeowner. And I think that's the starting point that you start with. So you don't start with, oh, but net neutrality, because net neutrality was coined by leftist law professor Tim Wu at Columbia, who, by the way, who's been working in the Biden administration and has been an architect for a lot of antitrust attacks. He's the person that's been behind a lot of the antitrust attacks on big tech and on the patent system. Who said to me, actually literally said to me 15 years ago when I gave a workshop talk at Columbia, and we were at dinner and I was having dinner and he was sitting next to me, and I forget specifically what we were talking about, but he became very agitated. He said, I just don't understand why people are opposed to price controls. And he's like, and he turned to me and he said, Adam, are you opposed to price controls? And I said, yes.
Yeah, absolutely.
And he was so taken back by that, the cognitive dissonance. So then he said, well, on theoretical or practical grounds. And I said, both. And he was so flummoxed by that. It was such a funny exchange.
So what do you make of the argument about common carriers, right?
Yeah.
So it is true that not AT&T, I don't know, who do I use? Yeah, I use AT&T. That AT&T cannot discriminate on who uses its network. Mm-hmm. Is that obviously that can't be legit, but that's the law.
So so that's a bad law, and it's a bad law, that it actually has roots in the common law, because the common law wasn't perfect, just like the founders weren't perfect, because they didn't have a full, consistent, rational theory of rights, so they didn't fully understand these issues, and it was actually a derivative byproduct, actually, of common carrier doctrine, this idea that if you serve the public in some way, you run a road, you run a railroad, you're a quote common carrier, and therefore you're going to have duties imposed upon you in terms of prices and who you can serve and things of this sort, or who you can't discriminate against, generally, not racial, just anything. And it actually derives from from the crown. So it shows you how, like, in England 300 years ago, if you wanted to set up a market or create a hotel or create or an inn, as they were called, or set up a road, you had to get permission from the crown. You had to get a grant from the crown. And when the crown gave you the grant, the crown, as the king, imposed all these duties on you and said, well, I'm giving you something. So you take the king, get the benefit of the king, you get the obligations to the king. And this got transferred into it just through legal process, through legal argumentation, into just the common law, and got applied to all the corporations and new companies that were being developed in the 19th century. It's a bad concept. It shouldn't exist. If you create a company that sells a product, that doesn't create any special duties on you any more than an individual who says to friends and other associates, you can come onto my property. Now, when you say that, you might create specific obligations given the nature of your interactions with those people. And there's really good doctrines in tort law and contracts about these matters. In fact, some of the problems that were identified, some of these so-called problems that were identified by the advocates for net neutrality, which was to impose very severe, heavy-handed regulatory common carrier obligations on internet service providers and the people who manage traffic on the internet. A lot of those were just straightforward violations of contracts and other kind of straightforward kind of just rights violations that could have been adjudicated and addressed through those mechanisms. In fact, that's one of the problems in the law. When you create bad law, it drives out good law because people stop thinking about the ways in which good law can address these issues. So it's the legal equivalent of, in economics, of bad money drives out good money. Bad laws eventually crowd out and drive out good laws.
All right. Yeah, and the common carrier stuff is big now with the internet and Twitter and all that.
Well, it's come back because, yeah, and it's the conservatives now,
Yes.
As it's always conservatives who end up being, the people who end up abandoning these principles or going more to their more fundamental principles, and doing this because they're so upset about the censorship, so-called censorship, which is also not a term that should be applied to Twitter and your private companies, but that that they are then saying, well, we need to find a way to address it. Well, there's antitrust and there's common carrier duties and stuff. And so you would think at a superficial level, they're willing to sell their soul just because to stick it to these companies that they feel that they've been harmed by. But actually, I think it's more fundamental. They're going to actually, what are the foundations of their soul?
Absolutely. All right. Michael asks, thoughts on mens rea?
Mens rea.
Mens rea, it doesn't seem just that if someone doesn't know they're committing a crime, that they still get punished because of their intent. Why are squatters' rights not a criminal matter? All
right, there's a couple different questions in there, so I'm going to disentangle them. Yeah. So
okay.
All right. So let me back up and be law professor for a moment.
Yeah.
So for those who don't know, mens rea is the requirement in criminal law that you have criminal intent. Mm-hmm. So it's not and these are Latin terms. So to be guilty of a crime, you have to actually have mens rea, you have to have criminal intent, and you have to have actus reus. You have to have acted on that intent and committed the crime. So there's no such thing as an accidental crime. So if you don't have intent, but you commit the action, it's not a criminal act. If you have the intent, but don't commit the action, it's not a criminal act. Now, but like attempted murder is still a valid crime because in those instances, it's just an accident sometimes that you didn't commit the crime, right? You shot the gun, you just missed.
Taking actual action, yeah.
You did take action on the basis of a criminal intent, and that's what we're punishing you for, right? So, and by the way, this shows this was developed at common law. Shows you the objectivity of the law, right? It's not just about action because people can take actions that are not intentional or accidental. I can trip and bump into you, and you could be injured by that. And I've injured you, so I've committed criminal battery, and I should be thrown in jail. it was an accident. Now you might be able to sue me in torts if you can show that I was not being reasonable and that's why I tripped, but it's not a criminal matter. And this is so it's the objectivity of the law. It's also a really important limitation on the use of state coercion, because it really limits what the government can classify as a crime. This has all been thrown out, by the way, in the modern era with the administrative state. Now, anything's criminal, unfortunately. So mens rea is actually a legitimate concept, and it's a good concept. Now,
and there's the squatters' rights.
Yeah. Now there's so to address the squatters' rights issue, I'm going to step back again. So I mentioned earlier private law. So I didn't mention the other. There's two foundational kind of divisional concepts that we have in legal theory or jurisprudence: public law and private law. Private law is the law that governs interactions between private individuals. So that's torts, contracts, and property. And then there's public law. Public law is the law that governs the state and the state's use of coercion against individuals. So public law is constitutional law, because that's about limiting the state, and it's criminal law. Is primarily, and then administrative law is a type of public law because it is the state acting. Now they can overlap, right? So you can have matters that you can have private rights of action about, right? Private complaints about. So a squatter is guilty of a private cause of action for trespass. I can sue them in court for trespassing on my property rights and get damages and an injunction to kick them off. They're also committing a crime. Trespass is not just a private cause of action in property law and torts, it's also a crime, as it should be. And so if a person you can show mens rea, they intentionally did it, they deliberately did it, and it was more severe than just a mere trespass, you can also have it prosecuted as a crime. And so you have this overlap, and we've seen this before. Probably the most prominent example was O.J. Simpson, where he got off on because his lawyers were able to razzle dazzle and confuse the jury so that they didn't realize that you had a guy who committed first degree murder, and multiple murders, and he got off on the crime, and because of double jeopardy, he can't be prosecuted. You can't be prosecuted twice for a crime. Another very important limitation on state power. But then he was sued for wrongful death, which is a private tort, and that's why they got millions and millions of dollars in judgment against him. And also because the standards of proof are a lot lower, because you're not talking about the government coercion in that context, you're talking about payment of damages.
So can the police just kick a squatter out of private property, or does this have to go through a court and a whole process?
The police, if there is a squatter, and they're being deliberate, and it's clear that they're squatting on someone's property rights, the police can forcibly remove them from the property. Yes, if they refuse to leave. But it has to be clear it's a squatter, right? So if the person's there saying, "Well, I have a right to here, and here's this lease," right? That I signed, and police aren't lawyers, and their job isn't to resolve those types of disputes. So if there's some lack of clarity as to what the nature of the dispute is, they may not take action.
And there seems to be some states in which squatters have more rights or more allowed more leeway than other states.
Yes,
it's harder to get rid of people in California, easier in Texas.
Well, and we should be thankful we don't live in England. England, they have absolute squatters' rights. So there are stories of people who go on vacation and they come home and there's someone in their home and they can't get them kicked out.
Really?
Yeah, because the rule is as long as the person is in the home, they have a right to be there. And so that's the rule in England. And so of course, if the person leaves, then the person who actually has title, legal right to the property can then close the door and lock it and keep them out. But so some people arrange for their friends to bring them food and stuff like that, and they never, yeah. So there are these issues, and then there's also a really cool doctrine that I teach, because I do the first year property course, which I love teaching. Every year, just taught it last semester. There's a really cool doctrine that had developed at common law called adverse possession, which is a really fantastic doctrine, which basically says, look, if you're an absentee landowner, who just has this piece of paper that says I have legal title, but you're not doing anything with your property for a significant number of years. Usually it's about 20, it's about 20 years, sometimes 30 or 40. And there's someone else who comes on the property and for 20 or 30 years is living openly on the property. Like they build a house, they cut down trees, right? So all the property owner had to do once in 20 or 30 years is come out, look at the property, see the person and say, hey, you're on my land, you're trespassing, get off. That's all they have to do to stop it. Yeah. But if they don't do it, then when they eventually come around, they'll say, you've lost your right. This person has been doing everything with the land that is fundamental to what we mean when we want to protect property. They've been engaging in value creating productive activities with valueless materials in the world. And you've been sitting back for several decades with a piece of paper that says legal title. And that's not what makes property property. It is a great example of the common law is not a legal positivist regime. It always was focused on the underlying reasons for why we have property contracts and why we protect people's bodily integrity through torts. Yeah.
Yes, I like that too. I talked about it on the show a while ago. Some people couldn't believe that you could actually lose your property right by not doing anything with the property. But yeah, I think that's completely objective. All right, Caleb says, and I'm not sure exactly what another question by Caleb, but we have two questions by Caleb. All right, Caleb says, from what I hear, to get work as a screenwriter, you have to be in the screenwriter guild, but the guild will own anything you write, and almost always studios will just fire you and hand your IP to other writers. Is that true?
I don't know. I don't know the structure of the guild system for screenwriters. I'm sorry.
It is pretty nasty, from what I can tell. Yes, guilds. You got to be suspicious of guilds in the 21st century.
Any organization that calls itself a guild. Yes. There's a reason. There's a phrase, guild socialism, and there's a reason. And so so you're automatically suspicious of anything that calls itself a guild. And because guilds are we're created to be protectionist. In fact, if I can take a moment to say something here, this is another important and significant aspect about intellectual property, which shows you again, like the libertarians who are in the world of theory and aren't actually looking at the history and how it developed and what it functioned as. Intellectual property served a key function historically for getting rid of the guild system. Because the guild system arose in the Middle Ages and continued through the Renaissance, because that was the only way at the time, since they didn't have intellectual property laws yet, that you could protect valuable tradecraft and knowledge and inventions, was by basically creating these little protectionist regimes where if you take your knowledge and give it to someone else, by the way, we'll kill you. And by the way, the rate of innovation from like 500 AD to 1600 AD is flat. There's almost no, the real hockey, the hockey graph is the innovation graph, right? The 19th century skyrockets. And by the way, what was it? What drove that was because intellectual property, because patents finally said, you disclose your invention. In fact, that's the key part of patents. They're published. In fact, they're published the moment they issue. So they're public, so other people can read them and invent upon them, and because they serve as your title documents, your title record for your property right, and that's the basis for you to get the license with people, because you can go and say, "Here's my patent. You can see it for yourself. It's at the patent office." So they say you can publish your knowledge, your information, and we will still protect it as a property right. Mm-hmm. And that was the key legal innovation that made people realize we don't need guilds. And this is a well-accepted, historians, economists tell this story all the time. And once you started having patents published as legal title deeds, so they were protected as property rights, people then licensed with them, transacted with them in the marketplace, people built upon them, right? So this is usually the people say, oh, well, see, it's totally locked up for 20 years, the term of the patent, and then it falls into the public domain. No, it's published. And so people then build upon it and improve upon it and then license with the original patent owner. And this is what is a property rights system. This is what drives economic growth and economic activity and creates a flourishing society.
Yep.
Sorry.
Okay, Calabos asks, no, this is great. I assume you've got another hour or so because we've got time.
Oh, yeah.
Caleb asks, wrote a policy review on PA oil and gas zoning laws in college. In retrospect, I'm not sure subsurface mineral rights should be granted to surface landholders in the first place. Any thoughts? I don't think they are they?
They are.
They are. Okay.
Yes, they are. Yeah, I did a show with Harry Binswanger on HBL or HBTV on this because this issue kind of came up in his email listserv stuff too.
Yep.
About so there's a rule at common law. It wasn't a legal rule. It was rhetoric, but it was called a legal rule, and that's caused confusion. Which is it's a Latin phrase, and it goes by the first two Latin words ad colum. Means the column, but the Latin phrase is he who owns the land owes everything from the heights of the heavens to the depths of the earth. So it means there's a column from the that goes through the land. So you get all the air rights and you get all the land rights. Now, the reason why it was rhetoric 500 years ago is people weren't building skyscrapers, and 500 years ago people weren't digging mines 2 miles underneath. If weren't fracking 500 years ago,
flying airplanes above your property.
Yeah. So it was a way that they were. So the function of the ad colum rule common law was to really just emphasize very strongly what it meant that you had what was called at that time also dominion in a property right, that you had full control over this area, that you could decide what you wanted to do with it as long as you weren't violating other people's rights. Well, when you started to get into the 19th century and the 20th century, where people are starting to build skyscrapers and stuff like that, people said, well, at common law, the ad colum rule. And they said, yes, we adopt the ad colum rule. And so then people would start. So when airplanes came into existence, people sued airplanes. You're violating, you're trespass because you're 30,000 feet and you're violating my property rights per the ad colum rule. And the courts rightly said, no, you're not doing anything at 30,000 feet. The courts rightly took the perspective again that property is a value that you are, meaning something you are acting to gain and or keep and are developing. And so they said that's not a valid claim. But with respect to mineral rights under the ground, they've retained the principle that no, you get the mineral rights going all the way down. And so this has then led to all sorts of problems and issues in especially caused by fracking, because it goes so deep and you have so many conflicting claims because the earth is not flat, it's a globe. And so you've got all these columns intersecting as you go straight down into the globe, and you get all these and so then they've created all these regulatory regimes to try to navigate these processes and stuff, and it's a mess.
Okay, so let's see. All right, Justin asks, can the novel combining into a new product class of two existing technologies owned by a single company be protected in favor of an external innovator?
I don't fully understand the question. So
he says, for example, NDA. I don't understand it either, but
so
yeah.
If you have one company create an invention, as long as it's new and novel and not obvious, and they've created it before the other company does, under the old rule, first to invent, whoever invented it first is the person who gets the patent.
Okay.
Under the new rule, it's whoever files first at the patent office. So I don't fully understand the scope of the question.
Maybe Justin can clarify, but let's move on in the meantime. All right, let's try to get short answers because it is getting late. So let's start with Apollo. Property rights in space. Who owns planets and asteroids? Mining for minerals.
Anyone who gets there first and sets up their mining operation. It's called the discovery rule in property law. Unfortunately, You don't have that in space because they signed in 1966. The UN created a treaty called the Space Treaty. It's called that, which prohibits property rights in space. What a great way to to totally just to disincentivize anyone's desire to go into space and to develop it. To tell them,
is Elon Musk aware of this? I mean,
I think he's hoping that
it's not enforceable.
Or he's hoping that he's going to be so successful that they'll junk the treaty. He will show that it's just not viable.
Okay, Landon asked, my tech company claims developers' product shouldn't research third-party IP for identification of acquirable features on our own. Is this reasonable?
It might be. It's hard to tell without knowing the exact product and things of that sort. But what they're concerned about is someone then saying, hey, you've incorporated into your product something that I already own, a copyright or a patent or a trade secret, and therefore I'm going to sue you for infringing my rights, for trespassing on my rights by taking my property without my authorization. I mean, that's the concern that they have for doing that. And that could be a legitimate concern. That's why a lot of the companies suggest that. Some companies prohibit it just because they also have a policy view that, oh, the IP system's broken. You can never know what truly is a patented invention, even if the patent's at issue, no one can read them. And so they tell their employees not to read patents for exactly that reason.
Yeah. So just to let you guys know, this show is in striking distance of Nikos, right? So about $100 would make Adam take the lead on the super chat interview. So
yes, let's make it happen.
We're close, guys. We're close.
Con law.
All right, Michael asked, do courts today typically uphold and respect patents, or do they see them as guidelines that can be ignored? Has it been getting better or worse over the last 30 years?
So the problem is no, it's been getting worse, but that's because courts are applying the law as created by Congress and their statutes, because the patent law is ultimately fundamentally a statutory system because it's set in the Constitution and Congress enacts the Patent Act. And then the Supreme Court, which then interprets the Patent Act, and the Supreme Court has been issuing really bad decisions in patent law in the past 20 years. In fact, the Supreme Court is deciding patent cases at a rate that we haven't seen for about 100 years. I mean, I think they've decided like 48 cases in the past 10-15 years. I mean, it's a really high number, and they've almost all been bad. And of course, then the lower courts have to apply those bad decisions because that's their job. And so, and this is something that I've been playing a significant role in terms of the policy debates in Washington, D.C. I've testified before Congress on this. And a lot of us have, are working to try to fix this by convincing Congress to pass new laws that will reverse these bad decisions by the Supreme Court, or reverse the prior laws that Congress enacted, and restrain the regulatory agencies like the antitrust officials from continuing to engage in their shenanigans as well.
Whoops, what did I do there? Okay, do Europeans have, also from Michael, do Europeans have an even lesser acknowledgement of intellectual property than American law does? Is that why so few innovations come out of Europe these days?
So historically, yes, the United States was unique in its patent system. We were the first country that protected patents as property rights. We took that principle seriously. So you could license it. It was a very expansive principle. Anything you invent, other countries were much more restrictive about this. Viewed them as regulatory entitlements, imposed what's called compulsory licensing. The state could just basically take the invention and and give it to other people and things of this sort. We didn't do those things because we said these are property rights, just like a property right in a home or a factory. And this is why we became a technological and economic leader in part, along with all our rule of law and other institutions. It's why we led the world and started in the Industrial Revolution and in the biotech revolution. It's why to this day, 2/3 of all new drugs are invented in the United States. And that's because we led the world in protecting drugs as innovations that deserve to be protected in the 20th century. The pharmaceutical revolution occurred in the United States because of that. So historically, we were better than Europe. Right now, though, we have so weakened our patent system that there are some respects in which Europe has actually a better patent system than we have right now. You can get patents on innovations in Europe that you can't get in the United States anymore. On cutting edge drug treatments, on cancer treatments, on new technologies that the Patent Office in the United States just rejects, given these bad decisions by the US Supreme Court. I've written on this and many others, and have testified on this, and there's a significant effort to try to fix this, but it's been difficult.
Different, Michael. Since firearms are property, and in a free society, the government has no right to violate property rights, wouldn't anti-gun laws be abolished in a free society? And he says, I'm not including nuclear weapons. I'm not sure why. Aren't those private property?
Yeah, isn't a tank a private property? A surface-to-air missile. So this is an example that it's a great question, and I don't mean to belittle it by then saying this is an example of a bit of rationalism in thinking about kind of property. I have a property right, therefore I can do anything I want with it, and I have a right to my life, and I can do anything I want with it. And I illustrate this sometimes to my students by saying, you can't say I have a property right in my gun and in my bullets, and so I'm just exercising my property rights by pulling the trigger and transferring my property to another person by putting the bullet in their body.
That one I haven't heard before. That's good.
And if you think, and by the way, I'm not making that up. People have made those arguments because you hear, if you've got hundreds of thousands of courts, hearing decisions over some centuries, you get all crazy arguments, right? Because that violates the conceptual hierarchy of that it's rights to life, liberty, and property, right? Property follows from the rights of life and liberty. You can't have a right, therefore, that denies or contradicts a more fundamental right, meaning the right to life. And so this is it is possible that there would be, so first of all, you certainly can't have tanks and surface-to-air missiles and nuclear bombs.
So why not? If it's property, what's
right? Those are weapons of mass destruction. Those are weapons for countries to fight against other countries.
So by me having them, it constitutes a threat to my neighbors, and you can't on your property create a threat to your neighbors.
Yes, it's an objective threat, right? Because how does your neighbor not know you're not going to set off the nuke? I mean, they can't, and that's an objective threat. Now, and also, you should have some restrictions on guns. People who have been adjudged mentally ill should not be able to buy a gun. People who've criminals and criminal records, I think it's legitimate to restrict their rights. Just like, by the way, they're restricted in voting. And they're, if you underage people should not be allowed to buy guns. You can't say, oh, it's a right to property. I've saved up my money. I'm 10. I should be able to buy an AR-15. That's not respecting context, and that's not respecting the hierarchy of how the rights function in society and how they should be protected.
Yeah, I mean, you can't constitute a threat to your neighbor, even if you build a building that looks like it's teetering and about to fall. The government has a role to come in and inspect and check if there's a complaint. If it constitutes an objective threat, they have a right to tell. They have an obligation to tell you to demolish the building or to fix it.
Oh, I mean, in fact, at common law, there's a whole doctrine that arose where people interfered with other people's property rights without actually going on their property, without trespassing. It's called nuisance, and it's an entirely legitimate doctrine. It's like, if you're creating toxic fumes, and the fumes are going over into your neighbor's house and is peeling their paint and is making their house unlivable, they can sue you for interfering with their property, for posing an objective threat to them, even though they're not physically coming onto your land. Having a teetering building is the same type of threat.
All right, Landon says, what would be ideal corporate policy for protecting against antitrust? I just went through some very left-leaning HR training on anti-competitive behavior for employees, which seems worthless.
So I don't fully understand what they mean by corporate.
Ideal corporate policy for protections against antitrust.
Well, at core, antitrust is non-objective, right? Because fundamentally, there's nothing you can do to stop the antitrust officials from coming after you, because at the end of the day, what constitutes an antitrust harm, a quote, harm to competition, is whatever they say it is, because it's not an objective definition. It's not tied to a actual harm that has been experienced by someone. And this is shown repeatedly, right? The Microsoft antitrust case. I remember that distinctly. The harms that were identified by the court to justify the antitrust punishment of Microsoft in 1998 was some people are confused by having Explorer already on their system. Some people don't want Explorer on their system and they can't figure out how to get it off. I'm serious. These are in the opinion as the identified harms that were created by Microsoft in bundling Explorer with its operating system and therefore violating antitrust laws. So there is no way to avoid it. Companies can try and they do, but you just try your best.
All right. Michael says, I've heard many freedom-leaning lawyers criticizing Marbury versus Madison as giving too much power to the Supreme Court. In a free society, what is the proper role of the U.S. Supreme Court?
Yeah, that's a really great question, because there is a lot of confusion about this, and there are a lot of mistakes by people, who get caught up in these attacks on Marbury v. Madison. Marbury v. Madison is the decision from 1803 that said the Supreme Court has the ultimate job of interpreting the Constitution, and excuse me, that the buck stops with the Supreme Court, essentially. It doesn't know a lot of, so conservatives like to say, well, it doesn't say that in the Constitution. So that was a power grab by the Supreme Court. So first of all, that's false, has been shown by legal historian Philip Hamburger, wrote a book called Law and Judicial Duty, that it was well understood at common law and for a very long time that courts that have the ultimate decision as to the determination of the interpretation of legal instruments and and whether rights have been violated or not. Now it's a valid decision, and it has to be valid because there has to be a final decider. For the same reason that you can only have one government. For the exact same reason, the same reason you can't have competing governments that that offer their alternatives. You can't have competing. You can't have different institutions within a government have equal say as to, well, we have equal authority that you can't talk. I'm Congress, so I can pass a law and the court can't say it's unconstitutional. Well, that's anarchy. Then what rule of law do you have? No one knows what the law is. You have Congress saying one thing and the Supreme Court saying the other. That's anarchy. And that's like the same situation you have with competing governments, allegedly competing governments, where you have two different governments saying two different things. And at the end of the day, what does that reduce down to? It has to reduce down to people duking it out with military force in the streets, because that's what happens when you don't have a state, a properly functioning state, which is an institution with the sole monopoly on the use of force in self-defense, defense of individual rights. And so there has to be a sole decider of what the meaning of the law is and what the meaning of the Constitution is. And by the way, that's why the Constitution has in it mechanisms for amendment. The founders saw this. They said, yeah, if the Supreme Court screws it up, you can pass an amendment to overrule the Supreme Court. And they've done that with amendments a couple times. The 11th Amendment does that. The 11th Amendment was enacted specifically. It's a complex issue that I'm not going to get into, but the 11th Amendment, the very first amendment enacted after the Bill of Rights, was enacted to reverse a Supreme Court interpretation of the Constitution. It's a valid decision. Judicial review is legitimate, and it's part and parcel of having a government.
All right. Apollo Zeus says, why does Adam like Spider-Man? Is it because of Steve Ditko?
Yeah, so it's funny. I'm a geek. I like the Marvel universe generally. I like DC, but I'm for people who know me, I'm more of a sci-fi fan, and also much more of a Star Wars fan. People know me for that, but I like all sci-fi. So Star Trek, Star Wars, Firefly, Expanse. As I joke, I'm sci-fi fluid.
Yes, Expanse was very good. So was Firefly.
Yes.
And there's the latest the latest Star Wars. What was it?
Oh, Andor, which is fantastic.
Andor was very good.
Oh,
Best Star Wars by far.
yeah, I 100% agree. It really shows you can actually do legitimate character-driven drama in the Star Wars universe. It's possible. Yeah, I
We
agree.
should do more of that. Maybe I'll become a fan then. All right, Len.
Join
Len
me,
says-
you're wrong.
Len asks, I really thought fracking was an Alberta, Canada innovation and discovered it is actual American. Well, you're not allowed to say American anymore, according to Stanford University. So, because the Canadians are Americans too, according to them, although Canadians deny it wholeheartedly.
Yeah.
Downhole Chemical Treatment et al. What makes your innovations patentable anyway? Horizontal.
What makes what innovations? Which one? I missed that one.
Fracking, I guess. What makes fracking?
Oh, fracking as a patentable invention, because there are patents on it. So there are several different types of innovations that go into it. First is the ability to drill that deep, which involves very highly specialized machinery, because you're talking about
Horizontally, yeah.
yes, well, but all at the depths that they go down to, the pressure and the temperatures are extreme. The fluid that's developed actually, the fluid that they inject down to crack the rocks, which is called fracking, that's actually protected by trade secret, that because that's a very high, that was a huge innovation in of itself. So there's massive innovations that went into making this incredible technology that for a brief period made the United States energy independent, right? We were actually at one point, we were actually exporting more oil, but this was like 10 years ago or 12 years ago, then we were we were a net exporter of oil for a few years, which is fantastic. It tells you innovations, what innovation leads to.
Let's see. Frank says, I wrote songs with my own music to words by Tolkien. I want to record them on a CD. If I try to sell it, will the Tolkien estate come after me?
So I can't give legal advice. You're asking about a very specific concrete act. My preliminary advice is, so my initial statement is talk to a lawyer, because the Tolkien estate does have copyright in all words written by Tolkien. And if you're using his words, that's raising a potential copyright issue.
It must be close to being in the public domain if it's not yet. So yeah,
I think he wrote in the 30s, and I think the cutoff point right now is 1923. Yeah, so like Sherlock Holmes and recently fell into the public domain and a couple other.
It could be soon. It could be soon. All right, but talk to a lawyer. How do rights apply to personal? This is hello there. How do rights apply to personal identification information? Also, is the court's power to subpoena witnesses in initiation of force? Yeah,
that's a topic. I remember debates in the 90s on back then on Usenet, which by the way were just as vicious.
Oh yeah. Oh yeah.
Rhetoric laden as the debates on
worse,
Twitter and Facebook. Yeah, this is just the nature of the internet, nature of human debates like that. But sorry. So identification. So I think he's asking about data, like your.
Yeah. So your personal data, I think.
So right now, unfortunately, the United States has taken the approach that you don't have property rights in data, which, by the way, is one of the fundamental problems which is kind of facilitated the issues with what's called to big tech, right? If you imagine if you had rights in your data, your property rights, right? They would have to get permission from you to use your data. And one of the reasons why they feel like they can do anything with your data is because the United States took the position, no, you can't have property in data. And now we're seeing a byproduct of that. And of course, the solution isn't to then recognize property rights where there should exist. The solution is to use antitrust and common carrier doctrine and all these other horrible doctrines. So they're just magnifying the problem. So you should have property rights in your data. And it would resolve a lot of problems if you did. Subpoena power, this is an issue. This is like in the abstract that people argue and debate endlessly in objectivist circles and libertarian circles generally. And I fall on the side that yes, subpoena powers are legitimate. If someone has information that is absolutely necessary for a court to do its job as a court, to resolve a dispute between two citizens, it can't resolve that dispute. And it may resolve the dispute improperly. If it doesn't get access to that information, then we're undermining the very function and reason why we have courts.
Let's see, Z Racer. Samsung literally had an internal document, 100 pages long, where, quote, here's what Apple did on the left, here's what we do on the right, solution, copy Apple. Next page, repeat. He's asking if you've seen that.
No, I haven't. I mean, as an, by the way, so like I said, Google was incredibly innovative. Their search algorithm, massively innovative, and they have brought information to our fingertips in a way that is unprecedented in human history, right? I mean, this is incredible, the world we live in today. You have the entirety of all of human knowledge available to you at a touch of a screen button. I mean, it's just incredible, and Google facilitated that. And so, they should be praised as innovators, but their policy positions have been awful. And because of their policy positions, they've done some really bad things, like deliberately infringe other people's copyrights and patents and things of that sort. And so you have to distinguish the company sometimes in their innovators from what the company's policy positions are. And I explain this in a certain sense when I tell people, like, you should be suspicious of Google when their motto is "do no evil," because no one wakes up in the morning and looks in the mirror and says to themselves, "Make sure you do no evil today." If you have to do that, you have a problem. You have a real serious problem that you need to address. So that's that. Yeah.
All right. This is a weird one. Let me just read this. I am 85% done writing a new objectivist constitution from scratch over the last 5 years. Can I get a voice call with Adam or Tara Smith to pitch it to them and gain their interest? Yaron, I am the genius whom Scott from Fabian Liberty told you about. Do you want to take a call from somebody who wants to pitch an objectivist constitution?
Sure. I mean,
an email they can send.
You just Google me at
Google Adam and send him an email.
Use Google, like I just said. Use Google. You can always send me an email. I get emails from people all the time. Yeah.
Or use ChatGPT. Microsoft is buying ChatGPT to compete with Google search, I think.
Oh, interesting. That's cool.
$100 million, I think.
Wow.
It sounds cheap, I think. But
by the way, I just want to say there's no such thing as an objectivist constitution. Objectivism is a philosophy. The drafting of a constitution and what goes into a constitution is not philosophy. Yep. That's political. That's legitimate political science, right? What they talk about in the Federalist Papers, that's political theory, that's legal theory, and that's law and politics at the end of the day. That's applied philosophy. And so there are objectivist applications in that space. But if you're thinking of this objectivist constitution, you're somewhat mistaken about what actually is objectivism.
All right. Friend Harper says, just got here. Has anyone asked about AI generated art trained on someone's copyrighted trademark? And if the artist can do anything about it, would it matter if the person with the AI art is making money with the image? So not that the image is copied, but it was trained using copyrighted art.
Yeah. This is that other AI there's an art version of ChatGPT that I played with someone, and it was really cool. And it really raises a really interesting question about at what point, how far do you get from the original work that by putting in your own choices about how it should be structured, that you've actually created your own original work. That's a fascinating question, and it's one that's going to eventually have to be addressed by the courts. And it's why you need courts, because it's a legitimate question.
It's not obvious what the answer is.
Yeah, it's not. You can't, and this is why this is why you have jurisprudence and legal theory and laws as a professional exercise, because you can't deduce straight from principles of the right to life, liberty, property, and contract to specific answers to specific legal questions, especially when they're between legitimately good people, right, who just happen to have a disagreement as to what the boundary line of their respective rights are.
Absolutely. All right, Justin's clarifying the previous question. So to clarify previous question,
Oh, good. Yes.
assuming I have cleverly combined into a new product,
Mhm.
two separate existing mechanical technologies
Mhm.
owned by a single company,
Mhm.
how do I protect the idea and sell it to said company?
Well, if you're working for the company in your employment contract, it says they already own it.
So I assume he's not working for them.
Well, if they've taken but if they've cleverly combined it, that's an act of invention.
So
And-
so he's cleverly combined it.
Well, oh, I'm sorry, he's cleverly combined it.
Yeah.
Yeah, well, then that's an act of invention. And if you've committed an act of invention, you should go talk to a patent lawyer to see if you can get a patent on it. In fact, most inventions, we usually develop
Combinations of
Wright
other-
brothers and, Thomas Edison. The reason why the Wright brothers and Thomas, they stand out is because they're the exceptions.
Yeah.
Most other, there's been, there's 11 million patents that issued. Most of the others patents are, as Yaron just said, are combinations of pre-existing materials. And those are just as important inventions, but their invention is still the same.
All right, last three questions. Len says, what about time limits on drug patents? Is that legitimate? What technologies would necessitate time limits? It seems that information and art is blurred with software, music, and dialogue.
Well, there aren't special limitations on drug patents. Drug patents have the same limitations as all other patents. So it's 20 years from date of filing of the patent application. Is your term of patent. Copyright is life of author plus 70 years, or if you're a corporation, you can live forever, so they can't go to life of author. So it's 90 years straight. And the issue of term limits in IP is one that drives a lot of debates and consternation. It's a complex issue. Ayn Rand addresses it actually in her essay Patents and Copyrights. I think she addresses it appropriately, but of course, being the genius, she addresses it like in 3 or 4 paragraphs because she instantly gets it and sees what the issues are. And me and every other normal person has to spend pages unpacking that and understanding it. And I did a whole talk on it at OCON about 8 years ago called Term Limits for Patents and Copyrights and Why They're Valid. And it's an example of how property is an abstraction, it's a concept. So you have actually different protections for different types of materials, given the nature of those materials as values as they're used in human life. So you have property rights in water, property rights in land, property rights in personal goods like your phone, your bike, your computer, property rights in stock and corporations. There's property rights in legal judgments. You can buy and sell legal judgments. And all of those property rights are structured differently because they all protect the exclusive control over something, but the thing is different in the nature of the value of how it's being used, so the protections are different. And given the fact that you're protecting underlying new innovations, that are the foundation of all value creation in human life, the further you get out from the original innovator, the moral claim of ownership diminishes in a way that it doesn't with with land and things of that sort. I don't want to go on much because I could go on for an hour about this. It's because it's a complicated topic. So I'd recommend people just listen to my talk. And if they have further questions about it, feel free to email me.
All right. Where do we get? Paul has a question. Okay, Paul says, after Apple created the Mac user interface, Bill Gates went by Apple, saw it, and literally decided to copy it in Windows and rip off the Mac GUI. What is the moral status of a company that did that and created so much value?
Yeah, it's similar to the earlier question about Google. Google stole, Oracle's, copyright. So, isn't that a moral company? So, by the way, it's not exactly 100% right because they didn't create the Mac. The actual people who created the GUI interface is not Apple. It was people at Xerox. In fact, the Xerox researchers were really upset when Steve Jobs and Steve Wozniak. And Wozniak, by the way, is the real technical genius. Jobs is not the programmer and a computer engineer. We're invited over to Xerox to look at everything. They're like, because the researchers were like, you're giving away the crown jewels. This is everything. And they knew it at the time.
But Microsoft still stole it because Apple licensed it and Microsoft didn't license it from it.
Well, so that's why Apple sued Windows, right? And what Steve Jobs said to, or what Bill said to Steve, famously was, your claims to IP, distinct IP in the Mac are not valid because they weren't original to you. Yeah, and that's true. The GUI interface was not invented by Steve Jobs or Steve Wozniak. It was invented by the people at Xerox. And so to the extent that he was claiming, I get IP rights in this, he didn't. And so Bill Gates had the right argument in that instance. I don't think of what Bill Gates did as immoral. In fact, Bill Gates is fundamentally a moral person in so many important ways.
Oh my God, you're in trouble now, Adam. I mean, it doesn't matter what you said up until this point. The libertarians, the conservatives, some objectivists.
I just lost everyone.
You just lost everybody.
Bill
Gates is the devil. What do you mean? He's buying up land all over the United States in order to poison us all. Haven't you?
I meant at Microsoft. I don't mean Bill Gates post-retirement. I mean Bill Gates at Microsoft. So he's responsible for the computer industry.
Absolutely.
So a lot of people don't know this. He wrote a very famous open letter. It was to what were then in the 70s called hobbyists, who we would now call hackers.
Yep.
It was a one-page letter that explicitly said, we have to stop stealing each other's work. Because at that time, the programmers were writing stuff and they were like, I can just take whatever I want and just make it. And he explicitly says, if we are going to make an industry, if we are going to revolutionize the world, we have to start respecting each other's property rights. We have to start respecting each other's rights. And he caught massive flack for that.
Oh, yeah.
He's hated by the entire programmer community, but he was fundamental to the creation of the high-tech industry as we now know it. For that reason.
Apollo Zeus says, is the lack of use of land the same? Is the lack of use of land the same as public domain law?
No. So public domain means completely unowned. So if something's in the public domain or in the law, it's res nihilus, totally unowned is the Latin term. That means no one had any claim to it whatsoever. And that's what space is, public domain now. And works that fall into the public domain can have no claim made on them. Non-use is just, I have a property right, but I'm not using it. Now, that can be legitimate in some non-use, physical non-use can sometimes be a type of use. Like, for instance, real estate developers, right, who buy up land because they foresee that that's going to be valuable land 10 or 20 years from now. So land can be an investment commodity, for instance, and that's a legitimate use of land. So we don't mean literally like physical use, but if real estate developer, if you buy up land, like once every 20 years, you need to go take a look at your land to make sure that there isn't someone actually that's now using it, that has been using it. And that's not that big of an obligation.
Okay. So this is the last question. I think Boaz has asked this.
Hey.
This is a different Boaz, but
it's a different Boaz.
Different Boaz. He asked this question to every single one of my guests so far. I haven't had that many, but he's asked it. It sounds like he's going to ask it to every single one of them. He's really uniquely qualified to answer this question, which the other guests were not. So here it is. Any tips for burnt out parents of a 7-month-old? So that's one. And then he says, just for the help, how to bring back focus and motivation. And what's your opinion on Bitcoin, blockchain, NFTs, Huawei, the Chinese company, AR, VR, and 3D printers? And all this for $5. So
awesome. By the way, did I top Nikos?
You did.
Yeah.
I was waiting to announce it. You are moved into the #1 position.
Awesome.
You've also topped him in time, so we're getting to 3 hours here almost. So
yeah, I'll go another hour.
I need bed.
You're not committed.
It's a question of the questions. Okay, so any tips for burnout parents of 7-month-old?
All right. Well, I have 3 children, 2 of whom are twins, so I know this quite well.
Yes, that's what I said. You're qualified to answer this. Nikos was not.
Yes, I I think my wife and I formulated a principle. We call it selfish parenting. And the idea is that, you know, yes, your children are important, but your life is at a fundamental level more important. And you have a relationship with your wife that's also very important, and you have to prioritize that. And you know, we set aside time, you know, where we were like, we're going to get a babysitter because we didn't have any family networks to fall back on. If you have family networks or something, you just do that. But if you don't, we didn't, you know, you just very selfishly have to set aside time and be selfish, and don't, you know, and say, yeah, it's good to convey to your child later in life that my values are important to me. You're a value, but your value should be important to you too. And this is in children pay attention to your action more than anything. In fact, my wife and I wrote children's vows to each other, where we explicitly wrote out that we committed to each other that even though we were having a child, that our marriage was a value, that and our individual lives were values, and that we were going to continue to remain committed to them. And the other one is, it does get better. It really does.
No question. No
Yes.
question.
Yes,
You know,
it does
it's another, you've got another 2 years or so, but it does, yes, absolutely.
Yeah.
Around 3, they become amazing.
Yeah.
Even at 2, they're pretty
Two-
amazing. Once
two,
they
they're
start
pretty good
talking,
at
once
two,
they start
yeah.
talking, it becomes.
The other thing,
But I liked every age. I mean,
I did too. I even
except
like
the teenage years.
but teach them sign language too. We did that with all 3 of our kids.
Oh,
And it's
interesting.
really awesome because, yeah, they figured out that kids can, one of the reasons for the quote terrible twos is that they understand what they want, but the vocal cords the nerves haven't formed yet, so they can't vocalize. And so they're expressing frustration because they know what they want, they just can't express it, but they can control their hands. And, you know, and you don't have to teach, you know, you have to teach them full sentences. You just
Sure.
teach them, you know, like this is more, and this is water and apple, you know,
Huh.
a few words like that.
Wow.
And it's amazing. And you're communicating with your kid at 1.
That's pretty cool.
Yeah.
All right. I don't know. Do you want to say anything about Bitcoin, blockchain, NFTs?
Yeah. Okay. So
Quickly.
Bitcoin Ponzi scheme, blockchain, kind of cool, but not really, hard to see what, you know, what's going to happen with it. NFTs, total flash in the pan type thing, I think. Not really fundamental or important. What was the other?
AR, VR, and 3D printers.
3D print, incredible. That will be a manufacturing revolution if it isn't already. It was AI, it said too, is it?
AR, VR.
AR.
So
Oh,
I think
virtual reality.
virtual reality.
Yeah, it has potential, but we're not there yet. I mean, so it's still too early, as I think the whole disaster of Facebook's virtual world is proving to be. And then what was the other one? So I can do lightning.
That's it. That's it. All right. So Paul says for the David Gogins of intellectual property. I take that as a compliment. I'm not sure who David Gogins is, but he's referring to you. Thank you.
I don't know who David Gogins is either, so that's why I'm okay.
Anyway, but it's a compliment. So he's
Thank
$20 to thank you. And then Ali, which will have the final word, he says, do you have a book? Have you written a book?
Unfortunately, no, because law professors primarily write our work through articles.
So where can he find your articles?
But all my articles are online and easily accessible at a website called ssrn.com. It stands for Social Science Research Network.com. I post all my articles there in PDF. It's downloadable, because law journals, you know, allow that. And so in fact, you just Google my name, Adam Mossoff, SSRN, you'll see my page come up and even some hits of my articles. And the nice thing about law review articles is they're accessible. They're easy to, you know, I pride myself in writing articles that are accessible and understandable. You don't have to be a lawyer to read my articles.
Well, this is great, Adam. Longest interview.
Awesome.
Most money raised in an interview. So we're getting to, this is like Lex Friedman length. This is
awesome.
We're competing with the big guys now. This is what's his name? The other big podcast who does 3-hour interviews. So this is great. Really appreciate it. I know it's late, so thank you. And yeah, look at him up. It's easy to find. I think the leading voice today in defending IP in the world, and is doing amazing work. Joe Rogan, yes, this is Joe Rogan length, like
Oh, I know Joe Rogan. Yeah.
There you go. Lex Friedman less so, but Joe Rogan, yes.
I know
This is
Joe Rogan.
All right, so thank you.
Well, thank you. This has
Have a
been awesome, Yaron. I'm really honored to have been
Yep,
invited.
this was a
Your
lot of fun.
audience asks fantastic questions. I really enjoyed myself.
The
man.
best audience on the internet. It's
Yeah.
by far the best audience on the internet.
Well, of course, it's your audience. That's why.
My audience. And I love them. So have a great weekend.
Thank
Say
you.
hi to your family. And
Same.
if I don't see you sooner, I'll see you at Ocon.
I
Maybe.
hope so. Yes. Yeah. I don't.
Somewhere.
Yeah.
I'm sure I'll see you somewhere.
Cross paths somewhere, but looking forward to it. Same. Best of the family.
Bye.